Might be the road. My lord, we have filed, or I have filed three things, my lord, a sort of detailed written submissions which I would like to place before your lordships. And then, my lord, there is a compilation of case law. And then, as my lord had said, there's also a compilation of the rules. My lord Justice Suryakant had said we should also file the High Court rules. So we filed those also in a separate compilation. If your lordships take, we've also provided printed copies of the written submissions. If your lordships either wants the PDF volume or the printed copy, either both are there. The registry asked us for printed copies, we've given that. Otherwise, it is in volume 1 are the submissions. And it's right at the beginning, my lord. In fact, it starts at PDF page.
PDF page 3.
PDF page 3 is the index, right?
PDF page 3.
Yes. PDF page 3, and otherwise, my lord, it's the index page of the printed copy. Your lordships may have the printed copy, otherwise, no problem.
1 to 50.
That's right.
Some say convenience compilation.
Sorry, my lord.
Amicus, sir.
Amicus.
It's, my lord, the written submissions.
Yes.
My lord, may I just start with the introduction, which is at page 1?
Yes.
Because this is, my lord, the orders passed by your lordships in this application that your lordships are considering. It says, my lord, by way of the present application, an anomalous situation in respect of the inter se seniority of district judges, direct recruits and district judges promotees has been placed. This Honorable Court's order dated 7th October 2025 recorded as follows. I'm just put two paras. This court, by the order dated 17 September 25, had considered an application filed by amicus who pointed out an anomalous situation in most of the states. Judicial officers recruited as civil judge often do not reach the level of principal district judge, leave aside reaching the position of a high court judge. This has resulted in many bright young lawyers being dissuaded from joining the service at the level of CJ. At para 10 and 11, this Honorable Court stated as follows. It cannot be disputed that judges who were initially appointed at CJ gain rich experience since they have been serving in the judiciary for a number of decades. Furthermore, every judicial officer, be it one who was initially recruited as CJ or one who was directly recruited as district judge, has an aspiration to reach at least up to the position of a high court judge. We are therefore of the view that a proper balance has to be struck between the competing claims. However, this issue would involve consideration of some of the judgments and orders passed by benches comprising of 3 learned judges of this court. Therefore, in order to put the entire controversy at rest and provide a meaningful and long-lasting situation, we are of the considered view that it will be appropriate if the issue is considered by a constitution bench of 5 learned judges. And then, my lord, the question framed on the next date, which was 14/10/25, is as follows. What should be the criteria for determining seniority in the higher judicial service? So the question, though wide, is, my lord, I have limited my submissions to the question as recorded in the 7th October order and, my lord, the application to answer this question to the best of, you know, what we feel we should be placing. It is respectfully submitted that seniority in the higher judicial service in various states, which comprises of a single cadre of district judges, though further divided into posts of district judge entry level, district judge selection grade, and district judge super time scale, ought to be fixed in a manner that district judges appointed by direct recruitment and promotion from the cadre of civil judges have an equivalence and a balance be struck so that no one category has an advantage over the other in respect of the said cadre, as also for further aspiration to advance the position of principal district judge, if any, and further to the position of high court judges. I say if any because not all states have principal district judge designation. So that's why if any is mentioned over there. Otherwise, my lord, some states have only district judge super time scale as the highest, and from there they are. My lord, now if your lordship just comes to the first page of the compilation, this is the way I've divided it into various, my lord, submissions. I've just, my lord, read the introduction. I've given a brief background, my lords, then a small discussion on the cadre of district judges, and then, my lords, for me to, or for us to impress upon your lordship that there is a requirement of a quota, some data has to be given. I can't just say have a quota without, so that is, my lord, serial number D, need or requirement for a quota. And then, my lords, fixation of seniority in the higher judiciary that deals with judgments also of your lordships. And finally, a summary of submissions and suggestions. So this is the way I've divided this note into the 4 or 5 minutes portions. If your lordship comes back to page 2, now this is where, my lord, the issue was first considered. Para 5, the disparity in the cadre was noticed in the first National Judicial Pay Commission, also known as the Justice Shetty Commission, under the chairmanship of Honorable Mr. Justice K.J. Shetty in its report. The Justice Shetty Commission submitted its report on 11/11/99. The Commission noted, I've set out some paras, my lord, for your lordship's consideration. The mixed cadre of district judges consisting of promotees and district recruits in every state judicial service was intended to promote efficiency in the administration of justice. But the fact remains otherwise. There is a lot of discontentment between direct recruits of district judges on one side and promotees on the other. The two classes are generally not on cordial terms. Nay, in some states, they are not even on talking terms. They are forming separate associations. They are locked in legal battles fighting up to the apex court. They made separate representations to this commission. The root cause for all these unfortunate fallout seems to be the mode of direct recruitment followed by high courts and determining the inter se seniority between promotees and direct recruits. The high courts are not unaware of this bitterness and discontentment in the service, yet seems to have done little to improve the method of direct recruitment so as to remove the grievance of promotees. The common grievance of service judges in the lower cadre in all the states, and which grievance is also highlighted in the memorandum of All India Judges Association, is that the hopes and aspirations of judges who have entered the lowest rung of the judicial service have been shattered for want of adequate promotional opportunity. It was explained that the unreasonable quota reserved and unscientific method followed for direct recruitment of district judges have practically driven the service judges to despair and despondency. It was said that they could never think of becoming principal district judge. It was pointed out that advocates are recruited as district judges at a relatively younger age, varying from 32 to 40 years, while service judges would get a chance of promotion as district judges only at their advanced age. Such direct recruits should be ranked above the promotees in the seniority list and occupy all the central posts. They also deprive the promotees the chance to reach the High Court. In the light of the aforesaid, the Justice Shetty Commission recommended the following. It seems to us that it is proper and necessary for all high courts to have a uniform procedure for recruitment of district judges. There should be uniformity as to quota minimum and maximum age and method of selection. Such uniformity is imperative since district judge cadre is a feeder service to the High Court and in some cases an onward march to the apex court. Since 10.80, since temporary posts are also available for direct recruitment, we consider not exceeding 25% of the posts in the cadre of district judges should be reserved for direct recruitment. This percentage of reservation would not jeopardize the interest of the promotees since we have decided to give them a certain weightage for fixing the inter se seniority besides providing opportunity to service judges to compete for such direct recruitment. We consider that there should be a minimum age for direct recruitment and it should be not less than 35 years. To put it more explicitly, the minimum age should be 35. Next, my lord, the Shetty Commission further noted that district judge entry level were provided career progression by way of grant of functional scales in the form of district judge selection grade and district judge super time scale, depending on their performance, and recommended that the cadre of district judges should be divided in the following manner. We have carefully considered the representation of High Court, state governments, and state and service associations. In our opinion, it is necessary to bring out uniformity in giving selection grade and super time scale to district judges in all the states. It is also necessary to prescribe the minimum qualification for entitlement to such grade or scale. These two scales are not to be considered as career progression scales. They are functional scales depending on performance. Commission recommends 25% of posts in the cadre of district judge in each state shall carry selection grade. This may be given on the benefit of merit cum seniority, on the basis of merit cum seniority to those who put in minimum experience of 5 years in the cadre. Commission further recommends minimum 10% of the cadre strength in district judges be given super time scale to those who have put in minimum of 3 years in the cadre of selection grade. Now this has become 35 and 15. Latest judgment of your lordships has amended that. Next, my lord, recommendation in respect of seniority is at the bottom of the page.
No. Become 25.
Sorry?
That's
No.
become 25.
No, my lord, I was talking about the selection grade and the super time.
Super time. Yes.
Because that is what page 4 is on. Otherwise, the lordships are right. It is 50% for in the cadre, 50% are directly promotees, regular promotees, 25% direct recruits, and 25% limited competitive examination.
LCD.
By this one, LC. My lord, may I just continue reading this a little bit?
Yes.
My lord, 12.106 bottom. This is the recommendation in respect to inter se seniority. Bearing in mind the aforesaid perspectives, comments, and suggestions made by High Court, state governments, judges, and service associations, we have made the uniform rules of recruitment and seniority for operation of all the states and union territories. The rules of recruitment inter alia provides as follows. Reservation for direct recruitment from members of the bar to the cadre of district judges should not be more than 25% of the cadre posts. This is a simple rule prescribing the upper limit for direct recruitment without any prescription of rota quota system. Then, the next is the age is between 35 and 45, and then the examination. And please come, my lords, to Roman 6, which is the rules of seniority. Seniority of the officers appointed by direct recruitment or promotion shall be determined according to the dates on which they report for duty. Where more than one officer is promoted to a cadre at the same time, inter se seniority of the persons who are promoted shall be determined by the inter se seniority in the lower cadre. With regard to direct recruits, inter se seniority is determined on the basis of the rankings in the select list. Weightage for promotees. According to the feedback information which we have received from the High Courts regarding average age of promotees and direct recruits made in the last 5 years to the cadre of district judges, the promotees will always be older in age to direct recruits. Reason being, civil judges, senior division, get promotion as district judges only at their advanced age, while bar members are directly recruited at a younger age. Then, there is a chart appended to the Justice Shetty Commission, which your lordships will see the difference in the various states. In Andhra, for instance, average age of promotee district judge 48, average age of directly recruited 39. Then Assam 51-38, Bihar 54-41. So in virtually every state, there is that age disparity. So this is why. Now this, my lord, is now dealt with at 12.110 and 12.111. It will be seen from the above table that average age of promotees would be about 50 years as against the average age of 42 years of direct recruit. Indeed, the table shows that in a majority of the states, such average age of the promotees would be above 50 years, while that of all direct recruits would be less than 42 years. Just pausing here, I have also compiled my own chart from the affidavits filed by the High Court about the position today, which is later on in the submission. So, Your Lordships may just see, in 1999 itself, the difference was 50 and 42. And now, today's position, I will be showing to Your Lordship. 12.111, my Lord. This will have an imbalance in the service conditions of promotees and direct recruits, and that is the root cause of frustration amongst the promotees. Apart from the imbalance in service, promotees would be denied of higher pay scales like selection grade, super time scale, etc., since it is given on the basis of merit and seniority of the officers. Promotees will not have any chance to become principal district judges of districts, since such posts are generally occupied by senior judges. They would be wholly denied of opportunity to go side by side with direct recruits in their onward march to reach the High Court. Even if they are elevated to the High Court, they will have hardly 3 or 4 years of service. Such a short period is not sufficient to make any worthwhile contribution to the High Court. The Commission considers that it is imperative to remove the frustration of promotees resulting from the aforesaid imbalance, and the only way we can think of is to give certain weightage to the promotees for the purpose of determining their seniority. The system of giving weightage is not new to service jurisprudence. It has been provided to officers of the state service when they are selected to all India services. The reference may be made to the Indian Administrative Service Rules. Then, 12.119. The Commission recommends that promotees be given a weightage of 1 year for every 5 years of judicial service rendered by them, subject to a maximum of 3 years. So, pausing here, so suppose a civil judge is recruited and spends, let's say, 15 years in the combined cadre of civil judge, junior division, and then senior division. For those 15 years, if that person gets promoted to to a district judge, will get 3 years benefit of seniority. Otherwise, he will start from the bottom. But this is the recommendation that the Justice Shetty Commission said. Sorry. Then, 12.120. Judicial service of officers for providing weightage is the entire service rendered by them as judicial officers, right from the entry into judicial service up to the date of promotion to the cadre of district judges. And so the next, is a summary of the above. And then, what your lordships had held in this very case in 2002 4 SCC 247, while considering the Justice Shetty Commission recommendations, is set out at para 10. Experience has shown that there has been a constant discontentment amongst the members of the higher judicial service in regard to their seniority in service. For over 3 decades, a large number of cases has been instituted in order to decide the relative seniority from the officers recruited from the 2 different sources, namely promotees and direct recruits. As a result of the decision today, there will be, in a way, 3 ways of recruitment to the higher judicial service. The quota for promotion, which we have prescribed, is 50% by following the principle of merit cum seniority, 25% strictly on the basis of merit by limited departmental competitive examination, and 25% by direct recruitment. Experience has also shown that the least amount of litigation in the country where the quota system of recruitment exists, insofar as seniority is concerned, is where a roster system is followed. For example, there is, as per the rules of central government, a 40-point roster which has been prescribed, which deals with quotas for scheduled castes and scheduled tribes. Hardly, if ever, has there been litigation amongst the members of the service after their recruitment as per the quotas. The seniority is fixed by roster points and irrespective of the fact as to when a person is recruited. When roster system is followed, there is no question of any dispute arising. The 40-point roster has been considered and approved by this court in R.K. Sabharwal versus State of Punjab. One of the methods of avoiding any litigation and bringing about certainty in this regard is by specifying quotas in relation to posts and not in relation to vacancies. This is the basic principle on the basis of which the 40-point roster works. We direct the High Courts to suitably amend and promulgate seniority rules on the basis of the roster principle as approved by this court in R.K. Sabharwal case as early as possible. We hope that as a result thereof, there would be no further dispute in the fixation of seniority. It is obvious that this system can only apply prospectively, except that where under the relevant rules, seniority is to be determined on the basis of quota and rotational system, the existing relative seniority of members of the higher judicial service has to be protected, but the roster has to be evolved for the future. Appropriate rules and methods will be adopted by the High Courts and approved by the states whenever necessary by so and so. Then, next, we disapprove the recommendation of giving any weightage to the members of the subordinate judicial service in their promotion to the higher judicial service in determining seniority vis-a-vis direct recruits and the promotees. The roster system will ensure fair play to all while improving efficiency in the service. Subject to the other various modifications, all other recommendations of the Justice Shetty Commission are accepted. So, my lord, the weightage system which was then recommended by Justice Shetty Commission was rejected, and the court took the view that you will follow the 40-point roster for appointment as well as seniority. 40 point for roster and seniority. Now, my lord, please see, one of the things that is arisen, and will come later in the note, is that let us say, my lord, the 40-point rosters worked when district judges entry level are appointed. Now, to the next grade, let's call it not a promotion, because most high courts call it promotion, although it is actually a functional upgradation as per Justice Shetty Commission. But let us call it promotion by merit comes seniority. My lord, there are no seniority rules, so the 40-point roster remains. In other words, what is happening is that people are actually being promoted more on seniority than merit. Otherwise, my lord, if it is merit comes seniority, then there has to be some change in seniority. The roster, 40-point roster will obviously be changed once, my lord, we go from entry level to selection grade, from selection grade to super time scale. If merit comes seniority is being applied, but in almost all states, it is virtually, my lord, the same roster system which is being for the entire card. And one of the reasons for that is, my lord, that the merit, determination of merit, some high court's rules have pointed it out and I'll show it, is basically on ACRs. Now, most people have those ACRs. 2 good, 1 very good, etc. That. So it all comes to seniority. So the criteria for merit is determined in a manner that seniority becomes the main thing. I'll show that in my submission. My lord, would your lordships turn over the page to page 9? Thus, this Honorable Court in terms disapproved the recommendation of the Justice Shetty Commission with respect to determination of inter se seniority of promotee district judges and direct recruit district judges, and did not grant the promotee district judges a weightage of 1 year for every 5 years of judicial service rendered by them, subject to a maximum of 3 years. Instead, this Honorable Court held that inter se seniority should be determined on the basis of 40-point roster, as has been considered and approved in R.K. Sabharwal. In the same judgment, this Honorable Court also held that the cadre of district judges would be divided in the ratio of 50 regular promotion as to 25 accelerated promotion as to 25 direct recruits. Thereafter, in All India Judges Association 2010, 15 SCC 170, this Honorable Court altered the ratio from 50-25-25 to 65-10-25 for appointment to the cadre of district judge. Recently, this Honorable Court in All India Judges Association, while relaxing the eligibility conditions for appearing in limited departmental competitive examination, restored the ratio for appointment to the post of district judge as 50-25-25 in the following manner. We find that if the quota of LDCE is restored to 25%, as originally recommended in the third AIJA case, which was reduced to 10% in the fourth AIJA case, it will provide an incentive amongst officers in the cadre of civil judge senior division. It will also provide them with an opportunity to get accelerated promotion in the cadre of district judge if they are meritorious and deserving. Another difficulty that has come to our notice is that sufficient number of candidates are not available for appearing in LDCE on account of requirement of having 5 years experience as civil judge senior division, which is prescribed as an eligibility criterion for appearing in the LDCE for the higher judiciary. In some of the states, a judicial officer who completes about 5 years service in the cadre of civil judge senior division in normal course becomes entitled to be promoted in the cadre of district judge. We have already framed issue 2 dealing with this very conundrum, which we are considering immediately after this issue. We find that in view of the answer that we propose for issue 2, sufficient number of judicial officers from the cadre of civil judge senior division would be available who would be eligible for appearing in LDCE. If in a particular year sufficient candidates are not selected from LDCE quota, it will be appropriate that such posts would revert back to the regular promotion quota based on merit cum seniority to be filled up in the same year. Therefore, in such a case, we find that no adverse impact on the administration of justice would occur even if LDCE quota is increased to 25%. In our view, this, apart from avoiding any adverse effect on administration of justice due to sufficient number of seats not being filled up, would also ensure that no prejudice would be caused to regular promotees, and at the same time, the said exercise would provide an incentive to meritorious judicial officer if their merit deserves the same. The next paragraph, my lord, your lordships have set out the time it takes. Now, this will also apply to our case that we are presently dealing with here. We find that it will be appropriate to compare the position in some of the states with regard to average time taken by civil judge junior division to be eligible for LDCE as against average time taken by civil judge junior division to become a district judge by way of regular promotion. In this respect, a chart was submitted extracted as under. Now, Lord, please see Bihar. Average time taken by civil judge junior division to be eligible for LDCE is 9 to 10 years. Not very relevant for us, but the next one. Average time taken by civil judge junior division to become a district judge by regular promotion is 9 to 10 years. If we come to Himachal, my lord, the average time B by a civil judge to become a district judge by regular promotion is 19 to 20 years. In Maharashtra, my lord, it is 13 years. So, the reason I'm pointing this out is now we have seen the 99 position in the Shetty Commission report. This is the 25 position which your lordships have set out. In Maharashtra, my lord, average time taken by civil judge junior division to become a district judge by regular promotion, 13 years. Next, my lord, Manipur. Average time taken by civil judge to become district judge by regular promotion, 11 years. In Punjab, average time by civil judge to become district judge regular promotion, 15 years. Haryana, 12 years. Uttar Pradesh, 9 to 10 years. Now, what your lordship said was that in the context of LDCE, the time that you became eligible for LDCE and regular promotions was almost the same. Therefore, there was no need for, people are not appearing in LDCE. So, therefore, your lordship reduced that time. But, my lord, what I am presently placing before your lordships is the time it takes for a civil judge to become a district judge is so long that, again, my lord, the age disparity will remain. And what that age disparity is, I'll show it to your lordship. Then, my lord, if para 42 at the bottom of page 11, as has been discussed herein above, the purpose behind providing a special quota for LDCE is to enable meritorious judicial officers to get accelerated promotion and enter the cadre of district judges at an earlier point of time than other less meritorious candidates. If a judicial officer even otherwise gets an entry in the cadre of district judges after completion of 5 years of service as civil judge senior division, there will be no incentive available to him or her. As already discussed herein above, in some of the high courts, a judicial officer gets into the cadre of district judge through regular promotion itself after he or she completes 5 years service as civil judge senior division. Therefore, in our considered view, it will be desirable to modify the requirement to become eligible for LDCE for the higher judicial service and reduce the minimum number of years of service of experience as a civil judge senior division from 5 to 3 years. However, at the same time, we are also of the opinion that, as recommended by some of the states, total number of years of experience for a judicial officer for being eligible for LDCE should be a minimum cumulative of 7 years, including service as civil judge junior and civil judge senior division. So this was in the context of saying that since you're taking the same time either way, you should reduce it. But what I am placing before your lordships is, please see the time taken for regular promotion. We are presently mostly concerned with regular promotion here. That still remains. Now, my lord, the next heading is the cadre of district judges. This very short, my lord, just one page on that. The second National Judicial Pay Commission in its report dated January 2020 recommended, having regard to the long passage of time since the recommendations were made by FNJPC, an undeniable fact that quite a number of district judges are not reaching higher grades, this commission is of the view that it would be appropriate and proper to increase the percentage of ceiling prescribed by FNJPC to a reasonable extent. Commission recommends that selection grade and super time scale posts shall be increased by 10% and 5% respectively. This means that district judges at entry level shall be 50% selection grade, 35% selection grade 35% and super time scale 15% of the total cadre strength of district judges. Of course, the criterion of merit cum seniority shall continue to be applied for placing the district judges in these two higher grades involving functional as well as financial upgradation. We recommend accordingly. This recommendation, if accepted, may be allowed to come into force from so and so. Next, my lord, para 16 in part 1, volume 4. The posts of district judges selection grade shall be increased to 35% of the cadre strength as against 25%, and district judge super time scale shall be increased to 15% of the cadre strength as against 10%. It will be effective from 1/1/20. Now, this, my lord, these recommendations were considered by your lordships in 2024 1 SCC 526, and at para 74, this is what your lordships had held. This commission has recommended the increase the percentage of district judges who will be entitled to district judge selection grade and district judge super time scale. The reasoning of the commission is that due to limited percentage of district judge super time scale and district judge selection grade, many judges from larger states are unable to reach higher posts before retirement even though they have spent considerable time in the district judge cadre. It is found that as of October 2019, only 1515 judges out of a cadre strength of 7382 district judges were getting the benefit of selection grade and super time scale. Recommendation of commission that the selection grade and super time scale posts should be increased by 10 and 5% respectively on merits acceptance. Essentially, this would entail that district judges at entry level shall be 50, selection grade 35%, and super time scale 15%. Now, so this was increased for the reason that judges should get an incentive to be in at least higher pay scales, and from there, you move to the High Court. Now, it will be worthwhile to see how many of these people, these judges may not reach selection grade and super time scale if you are a regular promotee judge coming from the civil judge senior division and before that from senior judge junior division cadre. And that's 50% of the cadre. We are dealing with 50% of the district judge cadre. What are their opportunities to reach these three scales within the district judge cadre? First scale, of course, is entry level, selection grade, and super time scale. Because that, I believe, is at the heart of what we are placing before your lordship. Now, according to us, the justification for that, we have tried to place at page 13 onwards, which is the need and requirement for a quota. We are saying that there should be a quota. What that quota shall be, I'll come to your lordship. So the first is the Justice Shetty Commission. As mentioned above, Justice Shetty Commission had noted that there was disharmony amongst promotee judges and direct recruit judges in district judge cadre, especially due to different average age at which promotee judges 45 to 50 years and direct recruit judges 35 to 40 years joined the cadre, which left to limited avenues for career advancement of promotee judges due to superannuation before being considered for the post of principal district judge or above. It was specifically for this reason that the Shetty Commission had recommended to grant the promotee judges a weightage of 1 year for every 5 years of judicial service rendered by them, subject to a maximum of 3 years. However, the said recommendation was expressly rejected by this Honorable Court in this 2002 4 SCC 247. The Honorable Court instead recommended adopting 40-point roster to govern the interstate seniority. It is respectfully submitted that the 40-point roster system, while determining the interstate seniority of district judge and promotee judges at the time of joining the cadre, does not remedy the problem of age gap at which the direct recruit judges 35 to 40 years and promotee judges 45 to 50 years join the cadre. The effective result of the 40-point roster system is that once the promotee judges superannuate to the higher age, the district direct recruit judges get clubbed together at the senior most positions in the seniority or gradation list due to the relatively younger age, and this stagnates the career progression of promotee judges. Despite having 20 to 25 years or more of judicial experience, due to seniority as determined by roster point system, promotee judges do not fall within the zone of consideration for being appointed as principal district judge. So what this para is essentially saying is, because they are at a higher age, they'll obviously superannuate much earlier, reach the age of 60 much earlier. So, because they may be, let us say, senior to a direct recruit judge, but the promotee judge will retire. Then the next promotee judge will also retire. So the top of the cadre will have, direct recruit, direct recruit, direct recruit, direct recruit. And then when the question comes for appointment, whether to the High Court or even to the next higher grade, it will be those people who will be taken into consideration. I've put a chart on the next page. I'll show that to you. Para 20 minutes. That the post of principal district judge in some states, others only have the post of district judge super time scale. Per se is not a promotional post itself, but an administrative post where a judicial officer from among the senior judges in the district judge cadre is appointed by respective High Court for administrative efficiency and management of a judicial district. Promoted district judges with adequate judicial experience may not even fall within the zone of consideration for appointment to the post of principal district judge. Creation of such a quota will not only be beneficial to promoted district judges, but will be equally beneficial to direct recruit judges who in several other states have been found to be not adequately represented at the senior post in the cadre of district judge. Having a quota for promoted judges and direct recruits will ensure that judicial officers coming from both streams have equal opportunity of progressing and gaining career advancement. So, we are saying that 25% plus 50% is the promotee judges, 50% regular and 25% LDC, and 25% direct recruits. Now, please see the way I put it or tried to put it to see how the quota helps everybody. It's one stream should not get the benefit, but both can get the benefit together is the way I'm trying to put it. The next page. The need and requirement of quota in the cadre of district judges may also be examined from the data on record provided by various high courts. So this is today's position. In certain states, it has been noted that an anomalous situation has arisen as per seniority gradation list of district judges, wherein it has been noted that the senior most district judges are found to be mostly direct recruit district judges, thereby leading to a lopsided situation where although the overall cadre strength of district judges is found to be in the ratio of 50:25:25, yet the post of principal district judge oblique district judge super time scale is occupied mostly by direct recruit district judges, and promoted district judges are not adequately represented at the post of principal district judge. This happens mostly due to average younger age of direct recruit district judges at the time of appointment to the cadre vis-a-vis the age of the promoted district judges. So this is exactly what Justice Shetty pointed out in 1999. Exactly the same. Now please see this chart. The following chart shows the difference in average age at the time of appointment of direct recruit judges and promoted district judges. Now, my lord, your lordships will see 35 in Andhra, 35 to 40. Sorry. Sorry.
Kerala, you have said 49 is the direct entry position.
Sorry, madam.
The
Yeah.
direct entry district judges, they get into the service at 49.
Right.
In Kerala, now there are at least 5 High Court judges who are direct entry people,
Right.
who are at this age, 49.
Oh, I see. No, I've just given the average. Maybe.
This is not correct.
So I'll just recheck it. This is my own, my lord.
It must be 39, 40.
Just check out the. My lord, I'll just quickly check. I may have made a.
Same thing with Bihar.
Let us see Bihar. My lord. The Bihar is not.
Bihar is not seen shown here.
So whoever's provided the data, I put it. The rest we have not been able. But my lord, just one thing to be added here. When your lordships are seeing this, this
Right, in Bihar, it takes 17 years to become district judge.
For the promotees.
for promoting.
No, no,
17
I'm
years
talking about the
On direct
direct
recruits.
recruits. I'm talking about the direct recruits.
My lord, I'm quickly checking the Kerala affidavit. Maybe it's a mistake. But one thing, your lordship will just note one thing here. The figures are, I think, more or less correct.
Right.
But my lord, when we come to the third, fourth column, average age of appointment to district judge, promoted judges, please add to this 3 years. Because now your lordships have said that you have to have 3 years as an advocate before you even take the examination. This data has come. This data is before this requirement has come into the picture.
53 will become 56.
Now, my lord, you add 3 years to it. Your lordship's judgment of 2025 May, when it was discussed at great length, and the Bar Council of India also said, and all the High Court said that
Almost all the High Court.
every High Court said that you just accept 1 or 2 Sikkim, etc., that you just can't have untrained, people without any advocacy experience becoming civil judge, deciding life and liberty. And so your lordship then mulled over whether it should be 2 or 3 years, and your lordship said 3 years. So now in this second last column, you will have to add, my lord, your lordship will have to add 3 years. What does it say? My lord, I'll just read that affidavit of the Kerala High Court. I'm sorry, I've taken it from here. I'm reading it, my lord, from here, if with the lordship's permission. Average age of judges presently serving in the cadre of district and sessions appointed by promotion from the cadre of civil judge senior division is 53 years, while the average age of judges directly recruited in the cadre is 49 years. So they've said on affidavit it may be.
We said that average age of judges now serving is 49,
Yes.
not recruitment.
Correct. Your lordships are right. That's a mistake, yes.
I would say.
Hmm.
These aged persons serving as PDG.
Please, we have
Right.
three of them who have first-hand knowledge, one on this
No,
side,
so, my lord,
two on the other side.
Well, I accept my mistake when going through so many affidavits, sometimes a little bit of. But all I'm saying is for this chart, please, my lord, while considering this, add 3 years in the second last column. That will have to, your lordship will have to add. Because, and minimum 3, because we are assuming that a person immediately after 3 years becomes a civil judge junior division. So minimum 3 your lordships add. My lord, just come into the next page 16. My lord, my apologies for that, I'll just correct it. Just check the others if there's any mistake. Affidavits keep coming and you quickly just sometimes write and this doesn't really.
Yes, that will be 25.
Yeah, luckily your lordships have that experience, your lordship immediately corrected me. So. But in fact, what your lordships are saying that the difference would be more than what I've indicated, not less. So it's, sorry. Hmm? Which example? Let's do it now.
There can't be an entry below 35.
Yes. Minimum is 35. Just see, may I just, now that we are mulling on this issue,
Both. Direct issue.
वो करना जरा 42 and 49 ना? No. Okay. Yeah, correct. It's a much bigger difference. One of the examples given by my
You see, this entire facts which you are referring to, this only highlight the anomalous situation,
correct
according to you,
minor.
that a kind of a explicit discriminatory
That's it.
or anomalous situation between direct recruits versus promoter.
Minor.
Those who are departmental, this limited
LC.
entry, 25%, to whom we can, just on loosely, we can call them semi-direct recruit.
Right. Because they are getting a, yes,
So they
advantage.
still might have an edge or advantage of seniority, might,
Minor.
depending upon that what time they compete and what time they get acquire eligibility and enter.
That's right.
Now this entire anomalous situation, what is the ultimate recommendation?
So, would your lordship want me to come to that first and then come back to it? Very well, I can mention that. But before I could do that, can I just mention two aspects, which, my lord, since your lordships were on LCE right now, just now, and also, my lord, recently we had a judgment of a constitution bench which says that even, my lord, serving civil judges after 7 years can take the direct recruit examination because the experience there is actually much more than that of an advocate of 7 years. That's what your lordships have said. So, my lord, one of the points that my learned friends have said, and it's a point worth, my lord, dealing.
Therefore, balancing of seniority
Yes,
is now also important because of that judgment.
right,
If you give so much incentive to the seniority for the direct recruits,
correct.
our junior cadre officer will start only working for
Then-
competing.
And they will not be interested in deciding cases, they will study for the examination.
Have a crisis in junior division level.
Exactly, my lord. So, you will spend 7 years preparing for the district judge direct recruit examination rather than doing, because then you are not bothered about your ACRs, etc., because you are only interested in taking the direct recruit examination. But, my lord, please see two examples that I am giving. My lord, one of the things that has been pointed out, it's certainly something I should mention straight away, is that LCE, which your lordship pointed out, and even the direct recruitment now gives some kind of equivalence to other people, which would include promotee judges. Now, the way they've said is this, that let us say, my lord, the case where a person graduates at the age of 23 years. Let us, my lord, take an example from law college. Then, my lord, that person will spend 3 years practicing as an advocate as per your lordship's judgment for 26 years. And then, my lord, as per your lordship's judgment, LDC, they can take after 7 years minimum. So, my lord, let us say 26 plus 7, 33. So, they are saying that at the minimum age, if you clear everything in the first round, you will at the age of 33 itself become eligible to become a district judge.
So
35 is the 35.
But so 33, but you take it to, so therefore you have no disadvantage. I was coming to that. 33 through LDC, 33 to LDC, but let us say you are appointed at 35 only. So the argument is there is no disadvantage. I am just dealing with that argument. Next is, my lord, let us take a case of a civil judge who after 7 years, as per, my lord, your lordship's judgment in the review in Dheeraj More, takes the examination and clears it. So, my lord, in his case also, he would have joined at the age of 23. Let us say, my lord, finished law at 23, 3 years, my lord, of advocacy practice, and then, my lord, 7 years. So that takes it to 35. So
We have made it that even in their case,
yes,
they can't get in before 35.
they can't get in before 35, but the argument that is being made is that therefore there are enough avenues for you through LDCE or through us for a civil judge to take the direct recruitment examination to come in at the age of 35.
And
Now,
so-
answer to this, let me give the answer. Sorry.
So their condition would be, whoever are meritorious amongst the promotee, they would have already made it by either through LCD or through the direct recruitment.
Right. So that is one of the arguments. Now, but please see the other side of it. 50% of the entire cadre is not promoted district judges. We are dealing with 25% LCE and assuming that the entire 25% is filled up. Your lordships have seen that in that matter when your lordships heard, hardly anyone was taking LCE. Now they will take because of the incentive. And my lord, you are assuming that every civil judge after 7 years will clear the district judge examination. So for 50%, we are dealing with the 50% of the cadre here. So, my lord, for them, the seniority and, my lord, promotion is a very important aspect. That's what I'm trying to say. So, my lord, to say that they've got opportunities, even after taking those opportunities, 50% of the cadre will still remain regular promoting cadre. So, we have to, so your lordship may think of that as that's what I'm trying to say, bro. Now, so, my lord, tell your lordships what my suggestions are and then I'll come back to this. Would your lordships come, my lord, to page 48? I've dealt with the case of the same, 48. I've given 4 suggestions in the alternative, etc. Try to be, my lord, as even-handed and fair as possible. My lord, just have a look at it. My lord, may I read suggestion 1 at page 48, Roman 1. The additional experience as judicial officers constitutes a reasonable and justified classification on the basis of which promoted district judges can be classified as a category who ought to be granted a quota for their effective representation at the post of district judge selection grade, district judge, super time scale, principal district judges. Creation of such a quota satisfies the twin test of classification based on intelligible differential and reasonable nexus of such classification with the object sought to be achieved. Therefore, creation of such quota is permissible in terms of so-and-so. It is thus suggested that for appointment to the post of so-and-so, now my lord, here, I'll just make there's a nuance here, which I'll just point out, to the post of district judge selection grade, district judge super time scale, principal district judges, a quota of 1:1 for promoted district judges and direct recruit district judges may be created. Principle of merit cum seniority may be, can then be applied within the said quota. So what the suggestion finally is that even for that 25% direct recruitment, you have a 50% quota, and for that 75% entire promoting cadre, you have 50%. That your lordships can of course make it 75, 25, 25. Also, some of my learned friends on this side are arguing that. But here, my lord, your lordship will have to see one nuance, that this district judge cadre has, my lord, 50% judges at entry level, 35% at selection grade, and 15% at super time scale. So, my lord, if we let us assume for a minute that this 1:1 quota is to be applied, and we apply it to both selection grade and super time scale, then there will be no entry level direct recruit district judge left, because 17.5% plus 7.5% will go into the next 2 posts. So, my lord, my suggestion here therefore will be to have that at the super time scale.
Only.
I hope I've made myself clear. My lord, let's say there are 100 posts in the cadre. So there will be 50 my lord entry level, there will be 35 selection grade, and 15 my lord super time scale.
Mr. Bhattacharya, that 25% departmental examination,
Yes.
the 25% quota, is only meant as an incentive
Yes.
for the officers who we suppose that they are meritorious enough,
Right.
that they can, through competitive exam, they can occupy those 25%.
Right.
What will be the incentive for them left if you apply this ratio in principal district judge or selection grade? And
No, because they will still be they are still promotees. Of course, no, the incentive.
therefore, why they should compete for 25%?
No, so
If ultimately this position is to be occupied solely on the basis of length of service, then what is the incentive left for them?
for the LC, yes.
25%.
No, then my lord, you will be senior to a regular promotee in any case in the seniority list. You will have a quota, yes, but your seniority will be higher.
Then are you conceptualizing a situation
Yes, sir.
where the senior most person in the cadre of district judge, though he is senior most, but he will not get a super time scale or he will not get a selection grade?
No, I'm not visualizing that. In fact, I'm saying the opposite. I'm saying the senior most. Suppose, my lord, the LCE person, let's say, my lord, there are 2 promotees appointed on the same day. One of them clears LCE at a younger age.
If on the same date they are promoted,
Yes.
nothing difficult, because then you can say that promotees will have an edge over the department
Right.
promoter.
My lord.
Then he can be assigned seniority. You can have kind of a roster point. You give first point to the promoter.
That's it.
Second
That's how the
to
roster is also. Yes.
third maybe to the direct report.
Correct.
That is one possibility. But what will be the incentive left for an officer?
Yes.
He will say, why should I work hard, compete, and try to qualify the exam, when eventually in terms of seniority or in terms of monetary benefit of a higher pay scale, I'm going to lose.
The benefit will be, in my respectful submission, this, that suppose, my lord, there are two civil judges, senior division, one is junior to the other. The junior one passes the LCA examination. He comes directly into the cadre of district judges. He becomes senior to the regular promotee when he comes in. So, my lord, the seniority will be higher in the cadre in any case. The quota doesn't affect seniority. Yes. Right. What I was saying, just, just to come back to what your lordship very rightly put to me. Firstly, at the entry level, we are not fixing a quota. So the LCE will anyway be senior. So entry level, will be as per roster, as my lord said. Only at super time scale will the promotees get. Now, that's one. Secondly, if I have just in fairness mentioned 1:1 as an amicus, but suppose some of my learned friends, etc., are saying the quota should be 2:1:1. That is to say, 2 for regular promotees, 1 for LCE, and 1 for direct recruit. Suppose that is accepted by lordship, then LCE again will get the.
Ultimately, 2:2 only.
Yes. I am saying that, but ultimately I am saying that the regular promotees are the ones who suffer the most because being maximum in the cadre. Coming to suggestion 2, which is the next page, page 49. Now here, it's the same as suggestion 1, except here we are saying something a little different. Alternatively, zone of consideration for appointment to the post of district judge selection. So please read this: zone of consideration for appointment of district judge selection grade and district judge super time scale should comprise of 50% officers from directly recruited district judges and 50% from promoted district judges. Thereafter, appointment would be made on the recommendations of the respective high courts on the basis of merit cum seniority. Thus, in the zone of consideration, 50% shall be senior most promoted district judges and 50% shall be senior most directly recruited judges. Now, suppose there are 10 posts. So most high courts have a system where the zone of consideration is 3 times. So let us say 30 officers, 30 judges will be considered. Now, out of which my suggestion is that in this zone of consideration, you will have 15 from the senior most promotee and 15 from the senior most directly recruited. After that, if the High Court feels that all 10 should be directly recruited judges appointed to the next grade, that is for the High Court to decide on merit cum seniority, or 5:5 or 10:0, whatever. But this is the zone of consideration argument, so that at least somebody comes within the zone of consideration. Otherwise, they are not in the zone of consideration. If it's 3 officers to be considered for 1 post, then obviously because of seniority, etc., they're never in the zone. This will bring them within the zone. This is the second argument. So this can be an alternative to the first in case your lordships feel that this is the better one.
Mr. Marcus, your suggestion, second suggestion, in fact will create a cadre within a cadre.
Why is that? I'm sorry.
Because you are saying that the 50%, let's say there are 10 candidates eligible for a super time or a special selection grade. It would be 5 from the promotees and 5 from the direct recruits. So what would happen is at the district judge entry level, it's a common cadre.
Yes.
And if the second suggestion is adopted,
My lord.
then we are creating a separate classification, a cadre within the cadre of direct recruit judges as district judges and promotee judges as district
Well,
judges.
with great respect, what I was trying to say is that they'll only be in the zone of consideration for being considered. Appointment can be of either of them, but they'll be the same. It's the cadre remains the same.
But for that, the list of seniority
Yes.
will be a different list of seniority for the district judges as direct recruit district judges and promoted district.
So that in
That is your proposal so
No.
far as.
so that is not exactly my proposal. I'm saying that in the same
That
scenario.
will boil down to that.
Correct. Now, but that is exactly what in my fourth suggestion, the High Court of Andhra Pradesh has said exactly this.
We've seen it.
Exactly this.
But the area of consideration would be,
Yes.
do we create a stratification in the district judge cadre,
my
which is an uniform cadre itself? We can definitely consider your first suggestion about quota in
Yes,
respect of the functional
That's the first-
seniority, functional position scales. But to create the cadre as groups will make it not an uniform, but a stratified cadre of district.
No, so I understand exactly what your lordships are saying, because then you are mixing up seniority in that sense. But my suggestion here is this is the only way in which if you are leaving it to the High Court to appoint a person and
It will also lead to a very anomalous situation
my lord.
where a person, because of this cap of 10 picking up from promoted, 10 picking up from direct recruit.
I'm not saying that.
No, zone of consideration.
Zone of
For zone of consideration.
Yes, yes.
10 you pick up from this side, 10 you pick up from this side, you merge them,
Merge them.
consider them, and then you promote them directly.
Whoever you want.
Maybe that throughout till the question of designation or promotion as principal district judge comes, an officer who have been throughout junior will become head of the district judiciary, and all persons who have been throughout senior to him will be under.
No, that may not necessarily be the case, because the High Court will consider it when we're making that appointment.
If you restrict the zone of consideration, then nothing will left for the High Court. Then it depends upon that if he qualifies, then you can't stop him.
I'm saying that presently the zone of consideration is such skewed in the other way. For that, if your lordship just comes to page 16, just have a look at the seniority list.
Probably you want to suggest the High Court will have to then very adverse responsibility of seeing that in which session division we are posting him and no person junior to him should be posted there. This will lead
No,
to
that I'm not saying. But
chaos.
Lord, eventually this is so. But Lord, I'll just show to your lordships how it works. In practice, what the problem is. I'll just show that immediately after I finish these suggestions. I'll come to the chart. There's a chart, and I'll just show after this. The reason I've come out with this, that's just a suggestion for your lordships to consider. Sorry. Well, the third suggestion is in fact what the Justice Shetty Commission had said. So I'll read it out. Alternatively, it is suggested that this Honorable Court may accept the recommendations of the Justice Shetty Commission and grant weightage to promoted district judges for experience in terms of 1 year seniority for every 5 years of judicial service, subject to a maximum of 3 years. It is further submitted that these additional years of seniority may be considered as service in the district judge cadre. Thus, if a promotee district judge has been granted 3 years seniority as per aforesaid criteria, promoted district judge will require only 2 years of service in the district judge cadre for being considered for the grant of selection grade. This is the example I've given. It is stated acceptance of recommendation of Shetty Commission will require modifying or dispensing with 40-point roster system for seniority in so and so. Thus, it was respectfully submitted will address the issue of age disparity and additional experience of promoted district judge vis-a-vis district judge, direct recruit district judge. So this is exactly what Justice Shetty had said in 1999. The next one is what my lord has put to me, so I'll read that also. 4. Alternatively, this Honorable Court may consider the recommendation made by a committee of the Honorable High Court of Andhra Pradesh, which had recommended 3 separate seniority lists in respect of promoted district judges by regular promotion, promoted district judge LDCE plus direct recruit district judge in the ratio of their overall cadre strength of 50:25:25 and the selection of such higher posts in the cadre of district judges be made on basis of such seniority list. So these are the 4. One has come from the Andhra High Court, one is Justice Shetty, 2 I have put in, my lord, as my suggestions. Now, my lord, just to come back to page 16, I wanted to show your lordships a chart as to the issue comes.
Page?
My lord, 16. My lord, we have been able to call out the seniority lists of some of the high courts. And here your lordships will see, let's say, my lord, Kerala. This is the seniority list. So Kerala has promoted district judge, promotee. So fair number of promotees at the top. In Patna, if your lordship sees, district direct recruit, then my lord, some promotees, then direct recruit, and then everyone direct recruit. So here we feel that if all these promotees will be older in age, my lord, to the direct recruits, and they will all retire before the other direct recruits, and the entire cadre at the top will become direct recruits. That is one of the things. Similar.
In Patna, that happened because 94 district judges were taken at one go.
It is mentioned in the affidavit, I'll show that.
That is why it
So that could be the reason, yes. The reason is not stated obviously in the
happened.
affidavit.
For 7 years, there was no recruitment at all.
Yes, ma'am. Right.
In Bombay, I think out of 21 studying I was happening the other day, 18 or 19 are direct.
Yes, so all I'm trying to say is that this clubbing at the top is the problem. And the clubbing will happen because even if a senior promoted judge is there, because of a 10-year age gap, he'll retire earlier. Or a 5-year age gap, he'll retire earlier. So that's the problem. My lord, turning to page 17, my lord, I've just culled out a few, my lord, paragraphs of affidavits on both sides, saying against and for both. Now, if your lordship looks at 17, this is what state of Uttar Pradesh is saying. Para 25, bracket A. In the state of Uttar Pradesh, there are 70 district and sessions judges, of which 58 are direct recruit district judges. So, my lord, these are actually principal district judges. Although they've called them, but these should be principal. 58 are direct recruit district judges, 12 are promoted district judges. High Court of Allahabad in its affidavit stated as follows. Out of 257, 137 officers are promoted judges by regular promotion, 2 officers are promoted judges of LDCE, 118 are direct recruits. Out of 100 senior most officers, 17 are promoted judges, regular promotion, 2 are promoted judges LDC, 81 are direct recruits. Senior most promoted judge features at serial number 29 in the seniority list. Therefore, posts at serial number 1 to 28 are occupied by direct recruits. The High Court is saying. Now, my lord, similarly for Bihar, your lordships had said there's a reason for it, but anyway, I'll place it. Out of 622 occupied posts, 91 judicial officers are working as principal district and session judge, consisting of 5 promotees and 86 direct recruits. As per seniority list and detailed chart, there are 20 direct recruit judicial officers presently below the 91 judicial officers working in the rank of principal district and session judge, meaning thereby that after the retirement of 5 promoting judges in the rank of principal district and session judge, all posts in the said rank will be occupied by direct recruit district judges. This is what this is. Then some other are there. I will not read all of them, but just if your lordship would just come to Andhra, because Andhra gave that suggestion. So let's see what they've said fully. That's at page 19, page para J. The High Court of Andhra has stated in its affidavit as follows: whereas candidates appointed to the post of district judge by direct recruitment are generally in the age group of 35 to 40, thus promoting officers always become juniors of direct recruits. Despite having put in more than 25 years of service, promoting officers retire in the cadre of district judges as they are junior to direct recruits and do not fall in the zone of consideration, and the judiciary is deprived of experience at High Court level. As per present seniority list, first 17 members were selected as district judges by direct recruitment, and considering their age, the promoted district judges will not get the opportunity to be considered for the post of High Court judges, even though they have put in 25 years of service. In the light thereof, the committee has made the following recommendations. Distinct seniority list should be maintained for each category of district judges: 1. Direct recruitment, 2. Recruitment by LDCE, 3. Recruitment by promotion. Recommendations for appointment of High Court judge should be made within these specified categories. Initial appointment ratio for district judges shall be consistently applied for subsequent appointment as principal district judges and further for High Court. The committee unanimously resolved to recommend that that 50% of appointments to the High Court from in-service officers should be drawn from the category of district judges who were initially appointed in the cadre of Civil Judge Junior Division, ensuring adequate representation. This is not the issue today before your lordship, but this is what the High Court has felt. Looking at the skewed ratio there, this is what the High Court committee itself is saying. This is not one of my suggestions, or this is not even the issue here today, but I'm just telling you, pointing it out.
You were told that even in state of Tamil Nadu also there is similar.
Tamil Nadu, I'll just show it. That's I think mentioned here. Just 1 minute. Tamil Nadu in their affidavit have said that 37 principal district judges, 27 are promotees and 10 are direct recruits. That they've said. At page 22, I've summarized it. In fact, page 20 onward, this is the view of some of the other states who have said that either the ratio is the same or promotees are more. So that also I put in. So, my lord, Chhattisgarh, Gujarat, Himachal, Jharkhand, Madhya Pradesh, Mizoram, Nagaland, Tamil Nadu, Sikkim, Uttarakhand, West Bengal, Delhi, and my lord, Jammu and Kashmir. So they are saying that in their states there are sufficient number, if not more, promoting judges. They have said that, so I put that also for your lordship consideration. Now, my lord, the other submission which I had made, which has been now set out at page 23, bottom, my lord. I'm just skipping over a few paragraphs because that we've already, my lord, covered that. My lord, para 31 at page 23. However, on account of the age by which promoted district judges are appointed to the post of district judge entry level, they suffer disadvantages in further promotions within the cadre. This is evident from the following. 1. First criteria considered by the High Court for promotion to district judge entry level to district judge selection grade is at least 5 years service as district judge entry level. If a promoted district judge is already appointed at an age far more than direct recruit judge, by the time a promoted district judge completes 5 years to come within the zone of consideration, the direct recruited judge of a similar age would have already completed 5 years and be within the zone of consideration for district judge selection grade or even district judge super time scale. Though selection and promotion in the cadre or oblique promotion in the cadre is on the basis of merit cum seniority, to be within the zone of consideration is also a facet of seniority, since the said zone of consideration depends on a number of vacancies. For instance, with respect to Delhi High Court, the zone of consideration is as follows. Delhi has 1:5. For 1 vacancy, for 2 it is 8, 3, 10, etc. And for Assam, Manipur, Meghalaya, Nagaland and Tripura it is 1:3. The ratios of 1:5 or 1:3. Next, my lord, if your lordship comes to my lord, para 33, which is at page 25. it is respectfully submitted that the benefit of limited departmental competitive examination, which has been given by this Honorable Court as an accelerated promotional avenue for civil judge senior division, has not led to an equalization in the district judge cadre. Now, this I am saying before your lordship made judgment. This is obviously not, that's not taken into account. Limited quota for LDCE was introduced in 2002, but data shows that it has not led to a significant reduction in the average age of promoted district judges vis-a-vis directly recruited district judges, because 50% of the promoted district judges are recruited in the cadre via a regular promotion, and in general, promoted district judges enter the cadre at a higher age. In this respect, paragraph 12.108 of the Justice Shetty Commission and the chart appended thereto becomes relevant, which I have shown it to your lordship. Since 2002, 75% of the posts in the district judge cadre have been kept for promoted district judges, being 50% by regular promotion and 25% by LDCE. However, the data provided shows no equalization in the higher posts within the cadre of district judges. It is then, my lord, I have given these examples which I have already given to your lordships. What is the minimum time that you take as a direct recruit promotee LDC? So that I have already shown to your lordships. And then, my lord, there are some paragraphs of this 2025 judgment of your lordships in, my lord, in the Dheeraj Moore case, which I have set out at page 26 for your lordship's consideration. Because to justify this quota, I am saying that there is a classification necessary, and that is a justified classification. One of the grounds will be this. May I read that, my lord, at para 36 at page 26. In a recent judgment, Constitution Bench of this Honorable Court in Rajneesh versus Deepa, in the context of eligibility of a judicial officer to be eligible for appointment as a district judge under Article 233 of the Constitution, held as follows in the majority judgment. Therefore, the question that is required to be considered by us is, if the purpose of recruitment is to get persons of necessary qualification, experience and knowledge of life, then as to whether the judicial officer who is in judicial service could be denied an opportunity to be recruited in the posts meant to be filled by direct recruitment. In that respect, we are of the considered view that it cannot be denied that experience a judicial officer gets by working as a judge can only work to the betterment of the district judiciary. The question that we would have to therefore consider in the present case is to whether such experienced persons having rich judicial experience can be permitted to participate in the process of direct recruitment for the post of district judge. I am using this to say that that rich experience can very well also apply for this the present purpose that we are not arguing before your lordships. We are therefore in full agreement with those observations made by Shetty Commission, according to which, in order to promote efficiency in the cadre of district judges, young, talented, meritorious judicial officers should not be denied an opportunity. Experience of a judicial officer. As a matter of fact, some of the observations made in the subsequent three-judge bench judgments of this court in the cases of Sushma Suri and Deepak Agarwal would support the view that we have taken. In both cases, this court held that merely because by virtue of being government advocates, the candidates who were in employment, their rich experience of working as a lawyer for government cannot be ignored. It has further been held that they continue to appear for the government side, either on civil or criminal side, the rich experience would benefit the judiciary. As already discussed here and above, the experience the judicial officers gain while working as judges is much greater than the one a person gains while working as an advocate. Apart from that, before commencing the work of judicial officers, judges are also required to undergo rigorous training for at least 1 year. And then, Lord, I'm skipping 147, 148. We therefore see no reason to deny an opportunity to such young, talented judicial officers to compete with advocates and pleaders having 7 years practice in the matter of direct recruitment to the post of district judge. Then, Lord, 157. In that respect, we are of the considered view that for bringing the advocates and in-service candidates at the same level, it will be appropriate that rules provide an in-service candidate should be eligible for recruitment to the post of district judge directly, only if he has a combined experience of 7 years as advocate and judicial officer. Similarly, if an advocate in participating in the selection process and he was a member of judicial service in the past, then his experience as judicial officer also cannot be ignored. His experience as an advocate prior to joining judicial service, his experience as a judicial officer, and his experience as an advocate after leaving judicial service will all have to be taken together. Such candidate will be eligible only if he has a combined experience as an advocate and judicial officer for 7 years. So, my lord, this judgment is proceeding on the basis, at least from what I've quoted, that judicial experience is very valuable. And according to my submission, which I've made subsequently with some cases, that experience of a judicial officer from the civil judge cadre is a valid ground for creating a quota as a valid classification. That's the way I've tried to put it.
Mr. Michaels,
Well,
when the super time scale or the selection grade
Yes.
is done,
Yes.
the experience as a district judge is taken into consideration, which is equal for the direct recruit as it is for the promoting district judge.
Correct. But the rules, sorry.
So the experience that you are talking of, the rich experience which cannot be denied, is equal for all of them.
No, my lord, what I'm trying to say.
You are trying to again add on the experience of a civil judge junior division,
Correct.
which is a thing which has already been factored in when 50% of the district judge posts have been reserved for the promoted district judge.
No, so that.
So won't it be amounting to a double benefit?
No, my lord, it is not a double benefit for the following reason, that within the cadre, when a district judge, a direct recruit comes in, he's starting from zero. He's starting from zero. A civil judge is coming in, your lordship, it may be a ground for his promotion to the higher cadre, but his experience is not wiped out immediately on promotion, is what I'm trying to say. The experience still remains. It is tantamount to saying that whatever experience of 15 years you've had is wiped out on becoming a district judge. With great respect, my lord, is my submission, ought not to be, my lord, considered in that sense, because a district judge, direct recruit, has zero experience. So you are in that sense equating zero experience with, let us say, 15, 10, 12 years of experience.
Like something. So Bhatnagar, there is
Right.
one another issue. Now, with the data you have presented as of now, in the cadre of district judges, all of them were recruited as junior division at the age of 27, 28. Because at that time, there was a prescription of practice. Now, for the last 1 decade, the things have drastically changed. They get into this thing at 23. We cannot go by this data alone. With 35. Last 2 decades. So this data cannot be relied on, because now the people are entering as a junior division at the age of 23. With the LCE also, at 35, they get a chance to go to the district judge level. The entire data would change.
No, so they get a chance to go into the district judge level by taking the direct recruitment examination. That's what your lordships are saying.
Direct recruit and LCE also.
LC also,
Both
but whatever stage, yes.
Now, when you say that the 50% are there, that is an informed choice they took
No, my lord,
to join as junior division.
I am saying, no, my lord, of course it's an informed choice, but I am saying that this data is of, at least from the year 2002 onwards, this data is not incorrect after that.
No, because the district judge cadre now has people who are recruited at the age of 27, 28 as junior division.
Yes.
That has changed now. For the last 2 decades, it's 23, 24.
No, correct. So in 2002 judgment, your lordships did away with the experience and again reinstated it now.
That is 3 years.
Correct. That's right. So let us say you come in at 23. I'm saying even then, if the disparity is so much, today the disparity will only increase. This data, my lord, whether we take it for 20 years, this data of disparity coming in at a younger age.
As Justice Bakshi said, you can probably provide a seniority at the time of recruitment. After that, how can it be?
No, but
Then you will be creating an artificial division between promotees, LCD, and direct recruits.
you know, that artificial division, in my respectful submission, is a valid classification, because you're taking it as your lordships have held this very judgment that I read out, that judicial experience is important. So if judicial experience is being taken for taking the direct recruit examination as being
Yes, Bakshi said that judicial experience is factored at the time of promotion, LDC, and all that. Why should it be considered at the time
Correct.
of super time scale? Because then what is considered is the experience as a district judge.
So that is exactly what Justice Shetty also said. You know, I'm not the only one saying it. Justice Shetty said it slightly differently. He said that you have to give them seniority in the cadre because of the experience. There also they've come into the cadre immediately.
But that was not accepted.
Not accepted, but I'm commending it to your lordship. You know, that considers the data of 1999 and came to this. You know, after all, one thing is classification. The other thing is, you know, equalization also. If 50% of the cadre finds itself in a position,
Is there any critical analysis by you based upon a comparative examination of the rule regarding determination of seniority in different states or in different high courts,
yes.
that the anomalous situation between promotees versus direct recruit, is it originating as a result of the seniority rule or as a result of the manner of recruitment?
So it is, yes, I've given a summary of all the rules.
The experience showed that if you go by the ordinary principle of recruitment, there will be no heart burning among the promotees, because as soon as the promoting vacancy become available, the High Court will either go by merit cum seniority or the High Courts will go by the this LDC, whatever 10% or now 25%, earlier also 25%. The problem has most of the cases arisen only on account of the direct recruitment taking place say after 5 years, and then you are getting the roster points of direct recruit in a presumed either rota quota or implied rota quota, and then you are getting a placement in the seniority list where you are not even born in the cadre, and that is has been the largely the
So that is one issue definitely. But the age discrepancy is also a very important issue. Not how do we ignore that? Not let us take the worst case scenario.
Mr. Marcus, one issue also has to be taken into consideration as to why in 2002 judgment of the All India Judicial Association, the lateral entries were permitted. It was to infuse more talent at various levels of judiciary and the promotion at every level, including the functional scale promotions or upgradations, are essentially on merit and not only seniority, that is age. That cannot be, you have to factor in that.
I'm factoring that in more. And I'm saying to your lordship exactly what Justice Shetty is saying, that although it is merit cum seniority, but to come within the zone, you have to be senior enough. You don't even come within the zone.
That is something which is not a classification of an uniform cadre, that is district judge, but giving some more additional handicap or advantage.
Some advantage.
To be promoted. That is well taken.
Correct.
But what is falling from us is that if your suggestion 1 or 2 of a quota in the functional levels are taken, or separate, as Andhra Pradesh has suggested, separate lists are maintained.
Correct.
We are actually creating separate classified stratas in an uniform cadre.
Which
perhaps may be a problematic.
Which I agree with your lordships. If let us assume, my lord, it is.
So if you want that age, there may be an area of exploring as to what additional advantages and weightages can be given to these promotees.
So, my lord, there is only one weightage, which is the weightage that was suggested by Justice Shetty, which is one of my suggestions.
So, Marcus, another issue is, as it is indicated to you by Justice Chandra, that see the evolving nature of the cadre. The cadre essentially started functioning for the last 2.5 decades.
Right.
It definitely gave an advantage to the direct recruits because of the age differential in the initial stages.
That's a submission.
And I can speak from my experience in West Bengal, today there is an equalization in the cadre. And the percentage of recruits from the direct channel and from the promotee channel are almost balancing out. So to make some changes,
My lord,
we must also bear in mind the evolving character.
correct. So I've placed those states also where there is an equalization, such as West Bengal. But, my lord, please consider, does this quota work against the direct recruits? If they are getting, let us say, 50% quota for 25% of the cadre, that actually works in their favor. Is my great respect.
You are dampening the merit factor. And you please bear in mind that the functional level upgradation is also merit cum seniority. And there we are, in fact, in some way restricting the Article 233, 235 powers of the High Court to make a merit-based selection.
It is restricted. That's one of my submissions, because otherwise, my lord, suppose it was not, it was fully being followed on merit cum on the seniority.
Better boy, quota mein.
Have you done any comparative analysis of the
Rules?
seniority?
So, yes, I have. There's a summary chart that is filed at the beginning of a compilation with every single High Court seniority rules, and they're all saying, my lord.
Between direct recruits to promoters.
Correct. So there they are saying seniority will be, most of them or all of them, that seniority is determined by the 40-point roster. Now the problem is that, now let me tell you what's the problem.
So the 40-point roster must be creating problem.
It certainly is.
Direct recruitment takes place in 2025.
Yes.
Vacancies of the year 2020.
Correct. So
that person suddenly occupies a place
absolutely
in 2020.
Right. Correct.
And those promotees in 21 to 25, they become junior.
So that is absolutely correct.
Therefore, That's why we are saying.
No. Your lordship's
true,
analysis is absolutely correct. That the roster system, in fact, that's why I've said the roster system requires the rework.
हर state में root cause सकते हैं.
And, my lord,
Roster failed because of
So,
functional
नहीं देखते हैं.
mismanagement.
that maybe there, my lord, that I
The
can't.
appointments were not regularly made for
That's
the
right.
deputies.
That's right. If it was made, it
You see a situation
correct. my lord.
where unforeseen circumstances, including administrative roadblocks,
Yes.
disable the roster system. That does not mean that the roster system was incorrect.
No, my lord.
There requires some tweaking in the functionality
And
itself.
not only that, so the roster system, the other problem with the roster system is, I find it very hard to believe that we have a situation where the 40-point roster seniority, because seniority is by the roster, continues for all three grades of the district judge cadre. If merit comes seniority,
Creating the district judge cadre, once you come into the district judge cadre, it's an uniform cadre.
It
You
is-
have already been given your advantage in the roster system of 2:1:1, which is the general roster followed in every state.
correct. So that advantage or according to me, it's not an advantage at all, which is what I'm trying to show to your lordships, because the roster is a seniority roster. Anyway, my lord, I will just.
We have to conclude because.
Yeah, so, my lord, I'll just take 10 minutes to show one or two cases. I'm sorry, my lord, I got a little carried away in the. I'm very sorry, my lord.
Yes.
I'm sorry, my lord, I took too much time. Would your lordship just come to page 29? I've set out 3 or 4 judgments, which according to me, my lords, are relevant. My lord, now I will not read all of them, but I'll just, my lord, since time is short, I'm just going to, my lord, summarize them. The first judgment, my lord, which is Mervyn Coutinho versus Collector, and the next judgment, I've set out the paras for your lordships to consider later on, and the other, which is Roshan Lal, my lords, deal with the situation as to whether persons drawn from different sources into one integrated class can be further classified. So that's the question. So now these two judgments, my lord, in the case of one was the Customs Department case, and the other, my lord, was a train examiner's case, said that you couldn't. I've set out the facts also
According to Mr. Basant, these judgments are against you.
against me. So now, therefore, my lord, I'm requesting your lordship to come to page 33, because this is the judgment which, according to me, another constitution bench, which is what I'm relying on. So for your lordship to consider. My lord, would your lordship later on just have a look at it? I've set out all the paras. If I read it, it will take too much time of both Roshan Lal and Mervyn, my lord. That's against me, correct? So I've placed all the paras. Please come to page 33, para 40. In State of Jammu Kashmir versus Triloki Nath Khosa, a constitution bench of 5 honorable judges considered the question of classification based on certain identified criteria. This honorable court considered both the above judgments, which is Mervyn and Roshan Lal, in the context of the following question. If persons drawn from different sources are integrated into one class, can they be classified for the purpose of promotion on the basis of their educational qualifications? That is the issue for consideration before us. The case involved promotion to the post of executive engineers from assistant engineers. Under the rule in question, it was provided that those assistant engineers would be eligible for promotion who possessed a bachelor's degree in engineering or held the qualification of AIME and had put in at least 7 years service. Honorable Court held that such classification was permissible for first identifying and then distinguishing members of one class from another, as the classification rested on reasonable basis and bore nexus with the object in view. You know, there are some paras, may I just read these? I'm sorry, there are 8 or 9 paras of this judgment. Judicial scrutiny.
You have 5 minutes left.
My lord, then, I won't read.
Or the others will have to curtail the time.
One of the most celebrated judges.
So I'm not reading it. I'm not reading it. My lord, just 2 points here on this judgment. I'll just mention the points at least your lordship may permit me. Para 30, page 35, if your lordship just sees, the distinguishing features between the case and Roshan Lal is at para, my lord, 45 onwards.
Yes.
And Mervyn Coutinho is distinguished at para 49. Correct, my lord?
Yes.
Now, please now permit me to read para 41. So, my lord, now because it's saying on a reasonable classification, you can have a promotion within an integrated class. Now, my lord, please let me read para 41.
Para 40.
41. This honorable court in a 7-judge constitution bench, now this is a recent judgment of last year, State of Punjab versus Davinder Singh. So this is not a sub-classification judgment. While distinguishing the judgment in Roshan Lal and held that Triloki Nath is the leading judgment for the proposition that the integrated class can be further classified if there is intelligible differentia and if the yardstick used has a nexus to the object of the provision. Reliance in this connection has been placed on paras 88 to 90 and 308 to 310. But 88 to 90 was of the then Chief Justice and 308 to 310 is by Lord the Chief Justice. and my lord had in fact agreed and concurred with that.
Yes.
So, my lord, I am saying 7 judges have now, in a sense, upheld Loki. So there's no question of further reference as was being argued the other day. That's my submission. This is the position. Next, my lord, there is a judgment that I've cited.
That may not have any application. Look at page 50. That Lokinath Khosa applies this classification only on the basis of educational qualification.
Correct, absolutely right.
Not
No. Now I'm saying experience as a classification. Also, I put a judgment. Experience being a valid ground for classification. For that, I was just coming to that. In fact, my lord, please come to page 44.
42.
44, para 45.
Yes.
This is now, my lord, Jagannath versus Union of India. It has been held that classification based on experience is a reasonable classification. In paragraph 7, in so holding, Honorable Court followed the judgment in state of UP versus Chaurasia. This is what Chaurasia says. Article 14 permits reasonable classifications founded on different bases. It is now well established that classification can be based on some qualities or characteristics of persons grouped together and not in others who are left out. These qualities or characteristics must, of course, have a reasonable relation to the object sought to be achieved. In service matters, merit or experience could be the basis for classification to promote efficiency in administration. This is the line I am relying on. Rest, I will not. I'll just mention one judgment for Lordship's consideration, which is Kuldeep Kumar Gupta. It's a 2-judge bench, but all these aspects have been considered in great detail. It's page 40 onwards of the submission. The paragraphs have been set out.
Paragraph 43.
If I read it, then it will take 10 minutes to do that. These are, my lord, the points for Lordship's consideration. Oblige.
Thank you. Yes, Mr. Giri. You are next in line. Okay. No, your list shows that you are prior to Mr. Giri. You are applying for Kerala High Court.
Page number.
इसमें भी होगा ना?
Yes.
Is it going to compare it?
Is it good? I think so, but it's different. So. This.
Permission? We are all interveners, but I'm representing promotees from state of Bihar.
Promotees from state of Bihar.
We have filed a separate written submission too.
So is this yours? At page 1?
Is it placed where? Volume 1?
Volume 1's lordship,
Page 100.
169. I understand, sir, this is your.
But
Page 169.
there is one physical compilation too, where the latest written submission which I could master, I have submitted. I won't be taking lordships to
On behalf of Rakesh Kumar.
Rakesh Kumar.
That's at page 168 of the.
168 of volume 1.
Right. 168 physical.
But I am not relying on the facts and figures. They have already been disclosed to lordships. There's no point in wasting lordships' time on that. Fact remains, insofar as state of Bihar is concerned, and along with couple of states from the facts as emerged from Amicus's written submission, there is a mixed kind of a not the perhaps indication. In certain states, the roster application to seniority has caused a little problem, particularly in my state, state of UP, and perhaps in certain other states like Andhra Pradesh and all that. But in certain states like Bengal, Madhya Pradesh and all, perhaps the situation has not been that troublesome. It's been quite fluid. So I would not be relying upon the fact that the percentages of posts that have been occupied by the promotees and direct recruits, that may not furnish a very strong ground for perhaps suggesting a rule of seniority. My submission is slightly different in the sense that, Lord, prior to 2002, the rule of seniority invariably and universally followed was the date of substantive appointment, which is the date of entry into service, and therefore your seniority will count on from that date. That was what was said by the Constitution bench in direct recruits case. So what your lordship said, that date of vacancy is not relevant. Retrospectivity cannot be given to the appointment. So the critical factor was date of substantive appointment into service. That would be the commencement of your seniority or the reckoning of seniority. It was in 2003, as a consequence of Shetty Commission's recommendation, that the lordships changed the rule of seniority. And perhaps it seems the lordships were impressed by Sabharwal's case, the enunciation of a roster application, and applied that to seniority. When this was done, when this seniority rule was changed, what was not pointed out to the court was that Sabharwal case is a case which is of a single selection. In other words, that was a case where promotees of different castes were vying with each other for, under different quotas, were vying with each other for promotion. So it was a single selection taking place simultaneously for everyone, and therefore adjustments could be made. It could be made through roster also, there was no difficulty. But in our case, tragically, my lord, the selection is threefold. One by direct recruitment, the other by the LCE category, and the third is by promotion. And all the three selections take place at different points of time. Sometimes direct recruitment doesn't take place, sometimes the promotion is delayed and so on and so forth. And consequently, then it becomes difficult to adjust by operation of the same roster. And what I borrow and which fell from Lord Justice Surikant was that the difficulty is arising when you start adjusting people who are promoted in the next calendar year into the roster and allow them to score a march over the others. One factor has to be kept in mind is that date of entry into service cannot be wiped away. We cannot go by the period of selection or the commencement of the selection or the advertisement of vacancy and all. That cannot count for the purposes of seniority, because otherwise we'll be giving retrospectivity to the appointment or promotion. Now, keeping this factor in mind, that retrospectivity beyond the date of a substantive appointment cannot be given, then we must, and we have to consider how to apply the roster. Roster can only be applied, Lord, if Lordship would see the Lordships in Sabharwal in the 2002 case, Lord, followed Sabharwal's case without looking into the fact that it was only single selection and therefore there was no difficulty in applying the roster. They applied it here. But the difficulty here was a threefold selection which were not being held simultaneously. And this difficulty was felt by Malik Mazhar Sultan, 2006 and 8. And therefore, their lordships recommended a time schedule simultaneously starting and concluding, so that all the three conclude at the same time, and then the select list is indicated, and then the appointments are made. Therefore, the year of recruitment would always be the same. and then you can adjust it in the roster conveniently without any difficulty. Or the other thing could be perhaps that you hold the separate selections separately and wait the select list till all the 3 selections are concluded and then issue appointment letters. There may be a gap of 6 months, 5 months, or maybe 10 months between the 3 categories of selection. And then thereafter appointment letters are issued. That perhaps will reduce the difficulty in fitting it seniority via roster. If this cannot be done, Lord, then the only way possible in my submission, respectful submission, is keeping the first factor in mind that no retrospectivity can be given to the appointments. The only way to adjust seniority via roster is that we have to run the roster year-wise. For instance, supposing selection commences, any selection commences, direct recruitment or promotion or otherwise, and it will always be the effort of the court and lordship that the selection would start, all the 3 selections should start simultaneously, close by. Now, once the selection starts, the roster revives. So roster comes into being, and roster has to be yearly roster. It can't be roster for n number of years. And that is where the problem which Justice Surikant pointed out will arise. If the roster runs year-wise, then supposing the direct recruitment takes place in 2018, and for some reason or the other, administrative reason or the other, or difficulty, or maybe a challenge, something like that, that they postpone the other tests or other selections are postponed to the next calendar year. Then the person who gets appointed in the next calendar year cannot be fitted into the roster points of this recruitment year. This recruitment year must end by 31st of December if it is calendar year. And the roster can run only till then. Whoever is appointed, direct recruit, promotee, or LCE, whoever it may be, he will be fitted as per the roster and will be there in the cadre of the additional district judges. The others who come later on next year, supposing the exams or the selection of the promotees is perhaps extended to the next calendar year, then the roster of next calendar year will have to be adopted and utilized. It can't be the earlier year, because then otherwise difficulty is, for instance, in the case of Bihar. What happens is the first 3 posts go to the promotees, the 4th goes to the, as per the roster, to the direct recruit. And then again 5, 6, 7, and so on and so forth. Now, if we, supposing the promotees promotion is not concluded in the calendar year, then the difficulty would be how to fit the direct recruit, because he's at item 4. And the promotees who get selected in the next calendar year or recruitment year, they come and occupy space before the direct recruit, and that can be vice versa also. So what I suggest, with humility, that lotships must look into this aspect, that the roster operation has to be yearly. It cannot extend beyond the calendar year or the recruitment year. Whatever recruitment takes place in any of the categories, they have to be fitted as per the roster.
According to it, it cannot be carried forward.
You can't be carried. Because the moment you start carrying forward, then the discrepancy and the haphazard allocation would start coming in. For instance, let's take a case where 3 promotees are appointed in 2018. The direct recruit selection couldn't conclude by 2018. Then we can't fit, next year when the promotees come in, or the remaining promotees of 2018, they can't be fitted into the roster because direct recruit occupies the 4th place. He gets selected in 2018, comes and sits over the other promotee. So that haphazard and perhaps incorrect, inappropriate application should be avoided. And the only way to avoid is to run the roster till the end of the year, and then whoever gets appointed for whatever reason, whoever gets appointed next year, he should come and fit in to the roster of the next year. So that he will always be junior. But the basic rule is someone who comes into service in the succeeding year cannot precede the person who's already been appointed substantively on his post in the earlier year. The person in the earlier year will always be senior to the one who's appointed subsequently. So this application of roster perhaps would resolve all the controversies with regard to the seniority aspect. Now coming to the other aspect, the promotees, because the Lordship has seen the difficult position of the promotees, particularly in my state, UP is also, and certain other states, Rajasthan, Gujarat, they're all having the same, suffering the same fate. So what I submit with respect is that there is no doubt that once the selections to the post of additional district judge or district judge entry level, we in UP called it more additional district judge, but in perhaps Bihar it is entry level district judge. Once they are appointed, they merge in the common cadre. There can be no dispute about that fact. I am not saying create a class within the class for further promotion. That's not the case. All that I'm saying is that since there are quotas prescribed for district judges level posts, it would be appropriate to facilitate the smoother transition to the higher category of posts by giving separate quotas commensurate to the population of the judge in the cadre. For instance, promotees, they are 50%. So you can give the quota of 50% in the principal district judge category. Likewise, about 25% direct recruits, they can get the quota of 25% in the principal judge category, and so LCE and so forth. What happens here is that we are not categorizing or classifying, or we are not denying anyone the promotion. They're all getting their due chances within their the population which the sphere which they occupy in the post of district.
Would it not be unfair to those coming through limited companies?
No, they will also get 25%.
They get 25%.
They'll get.
They, on account of their own merit,
No,
have come earlier in the cadre of district judges.
But can you bear in mind, as pointed out by my friend Rod,
They are again pushed back. So those persons who are enjoying the office without trying for competition to excel themselves, they will get it as a bounty.
no, then they have their own quota in which they can go up. It's not that the quota is not blocked at the top. Quota is open at the top. 25% LCE, that's an incentive given to those who want to get the faster promotion and are meritorious, more meritorious perhaps. Then they have their quota within which they can go 25%. And 25% would be more than adequate to accommodate all the LCEs. The Lordships have seen the data, Lordship has seen. Lordship would not get so many LCEs who can go over 25%. Likewise, on the other hand, look at the promotees. They form the bulk of the population in the cadre of district judge. And yet, from 26, the fact is from 2026 onwards, there would be no principal district judge in state of Bihar belonging to the promotee cadre, 50% quota. There would be no till 2035. And what will happen thereafter, we don't know. So the question is, at the moment, there are 90 principal district judges, out of which 85 perhaps approximately are the direct recruits. And 4 or 5 I think perhaps are
91, 86 and 5.
Now look at this, there's a skewed consequence. The 50% of the population has only 4 seats, while the 25% of the population.
Because of that anomalous situation. 7 years, no recruitment.
But that anomalous situation happened. That anomalous situation happens even in the promotee cadre. Because we got recruited in 2001. We got promoted as Civil Judge Senior Division in 2014. And then 2018 as District Judge.
Yes.
And entry level. So it has taken nearly 17 years for us to reach that stage. And at every stage, we have been considered to be meritorious to be selected for the higher grade. So it's not that we were worthless kind of, or the deadwood, as the lordships call it. So looking into this, my suggestions are twofold. One, let the seniority be determined on the basis of roster. For instance, in this case, in the state of Bihar, May 2018, direct recruits got recruited into the cadre. And in December 2018, the promotees got recruited into. Now, both came in 2018. So it won't be a very big catastrophic loss to anyone if 4 or 5 months loss here and there, but at the same time, you can adjust them very conveniently into the roster of that year. Now, if we start counting seniority by month and days, perhaps they may have a cause. But the fact remains, it can't be done. No? We are looking at the overall picture, how to run the system smoothly. So there, some casualty here and there will be there. So, but by and large, this system of running the roster per annum will reduce the friction to the minimum and let the system function smoothly. Add to that the quota for the principal district judge category post. For the separate categories, there is no classification as such. The Lokinath Kosa's rule will not apply here. There the rule was that the person who could have otherwise secured promotion, if there was no rule prescribed for higher education for further promotion, then he would have secured further promotion. So by this prescription of qualification, additional qualification, he got denied the opportunity. But here there is no denial of opportunity. We are giving commensurate quota to each category depending upon what the quota was in the earlier category.
So if the roster is to operate annually, the direct recruitment process starts, let us say in July. In June, July, we issue the advertisement, invite applications, hold preliminary exam, then written main exam, then interviews. And by that time, we are somewhere near end of the December. Someone filed the writ petition in the High Court. The declaration of result is stayed.
That happens.
Right? 31st December passes, New Year comes, writ petition is dismissed, found to be frivolous. What will happen in that case?
No, they are not in that particular list. Your lordship can always grant a decree or an order that can restore the loss.
Deeming fiction will have to be created.
Not
That for
fact remains
intents and purposes,
quite,
but for an unforeseen circumstance,
quite right.
they would have been appointed.
Quite right.
So therefore, you will create a deeming.
That very often lordships do, my lord. If consideration has not been done
So
timely, then lordships direct that they will be considered with effect from that.
The other side argument will be that if you have an annual roster and you fail to hold examination for any reason, not only fail to exam, you hold the exam, but if you fail to make an appointment for any XYZ reason, why eventually the finally selected candidate should suffer?
But may I answer this, bro? We cannot bring about any perfect system. Your lordship would never have that. There will always be a dispute, and people will dispute. We have been seeing it right from the days of Patwardhan Lord till date. Lord. Some dispute or the other comes whenever there are twofold quotas. But the issue and the idea which I am suggesting is to have the minimal friction, minimal disturbance, and minimal heartburning on either side, all the three sides. There would be some, there's no difficulty in that. There would be some which will require resolution, spot resolutions and things like it as and when it is required. But the fact remains, by and large, things should proceed smoothly. As the lordship said, 2018, if this direct recruitment concludes, he will be the direct recruits will be adjusted against the roster of 2018. But on the other hand, the bigger anomaly occurs, as the lordship noticed, that if we start adjusting people of 2018-19 selection in the year roster of 2018, then it becomes a little more anomalous. So let's see where perhaps the least amount of friction, least amount of heartburn, and least amount of difficulties. Then obviously we cannot have a perfect system. That is what I'm suggesting. And coupled with the quota at the top, perhaps each segment will proceed smoothly in its own. That's my submission.
Yes.
Yes, Mr. Pratik.
I'm grateful, Lord, and then before I end, Lord, there's one apology of mine, Lord. Sincerely, Lord, I must say, because on the last occasion I had mispronounced Lord Justice Chandran's name, Lord.
No,
So I'm extremely sorry for that.
N is an addition we have in South India. No big deal.
Well, that can be sorted out over a cup of tea or coffee also. I'm grateful.
Please, Your Lordships. Your Lordships, I'm appearing for the LCE category, Your Lordships.
For the
LCE category, Your Lordships. Unfortunately, in this whole battle, Your Lordships, we are the grain which has been sandwiched between the two stones. And the benefit which was supposed to come to us as an incentive, Your Lordships, is not coming to us for the basic fallacy of every High Court treating us as a part of the promotee group. Now, Your Lordships, from All India Judges 3 onwards, there are 3 categories.
Belong to which category?
LDC.
LDC.
Your Lordships, from All India Judges number 3 onwards, 3 streams have been created. So, in terms of considering for making the cadre of district judge, there are 3 streams. There are not 2 streams, direct recruit and promotees. There are 3 streams which are direct recruits, LDCE and promotees, Your Lordships. What has changed over the years, Your Lordships, from the 2002 judgment to 2025 judgment is only the numerical quota of LDCE, which is 25%, then it came down to 20% and now 10%, and now it has gone back to 25%. But the concept with regard to it being a separate and distinct category has not been obliterated since 2002 onwards, Your Lordships. Now, for that purpose, let me just point out, Your Lordships, 2 or 3 concepts which are required for the purposes of clarity, Your Lordships, how the seniority list must operate. First of all, Your Lordships, the feeder cadre for the post of district judge entry level is what has to be taken as a unit. The unit is not the further promotional posts in the district judge cadre. So when we are looking at the cadre, as per all the High Court rules, which I will show to Your Lordships, the cadre is of higher judicial services cadre. And it is the post of the entry level that we have to look at, where the seniority and gradation list will be made. Thereafter, Your Lordships, it will move in accordance with that basic entry level seniority list. The further promotions will be on basis of that. So that is the first thing, Your Lordships, that the cadre has to be at the entry level. The second aspect that, Your Lordships, is that how do we rationalize and ensure that no category out of these 3 categories steal a march or are left behind for certain administrative exigencies. As we have discussed, Your Lordships, it just fell from Lordship, that for some reason, suppose a promotion DPC doesn't happen. If there is no promotion which is done for the next 3 to 4 years, as what happened during COVID period, Your Lordships, there were promotions which were due but could not be given because of the administrative purposes, then at whose peril will that period, which has a valuable period, which we have lost, Your Lordships, at whose peril will that period go? So that anomaly has to be adjusted. And how that has to be adjusted, Your Lordships, is my learned friend, learned Amicus, has suggested 4 alternatives, Your Lordships. In my respectful submission, Your Lordship, each of the alternative is I'm sorry to say, a half measure. It is not a complete solution to the problem that we are facing. Many high courts have rules, and I'll just point out to your lordships, where the rules are on basis of cadre, rules are on basis of roster. However, they have not been applied consistently by the high courts. It fell from Justice Bagchi that the problem that is arising is not the methodology, but it is the application of the methodology, and I will show that also, your lordships. So the third aspect is this aspect, your lordships, that how is the quota to be worked out? Next aspect, your lordships, is whether it has to be worked out on the basis of post or vacancy. This is also a well conceptualized legal concept, your lordships. I'll give those judgments that the roster has to operate on basis of post, which your lordship has also taken in account in the 2025 judgment of All India judges, that the vacancy will be filled up from the same category where the vacancy arises, your lordships. Like we just discussed, your lordships, if there is a retirement, suppose there is a death, suppose there is no further promotion, then those vacant posts on the roster points arise. Those will be filled according to the category to which the roster point belongs. Next aspect, your lordships, is All India Judges 3. The basis of All India Judges 3, your lordships, for adopting R.K. Sabharwal was that in R.K. Sabharwal, which is the locus classicus, the caste-based roster was the workable method by which now, as per the experience, your lordships, has not been faulted at all. The method of the roster is working perfectly. And in that also, your lordships, we have multi-layered quotas. One will go to the general category. Next will go to SC, ST, OBC. So these are four broad categories in which the roster works, your lordships. So the roster system, by administrative experience, has been working very efficiently in that caste-based reservation. And that is why lordships imported the roster system by All India judges, the third 2002 judgment, your lordships. That having been imported, your lordships, the rules were made by various high courts after 2002. However, now the problem that has arisen is whether continuity in service is to be the criteria for the seniority to be adjudged. Some high courts do prescribe continuity of service. Some high court says that it shall be irrespective of continuity of service. So length of service in the feeder post, some high courts have said that it will be considered to put you in the seniority list. In some high courts, they have said that it will depend on the roster point, irrespective of the dates that you come into the position. The argument that is raised against this by direct recruit, your lordships, is that you are not even born in the cadre. So continuity of service is the best method to adjudge your inter se seniority. If you are not born in the cadre, you have not been appointed to the post of district judge, you cannot seek seniority over a previously appointed direct recruit. Suppose I am a promotee, your lordships. My promotion batch comes in 3 batches delayed, your lordships. But direct recruitment has taken place, the advertisement has gone out, and the appointments are made. I am due for promotion, say, in 2000, your lordships, but my selection process does not take place in 2000, it takes place in 2003. So the 3-year gap, then I come under the rank of the direct recruit person who has come in 2000. So what lordships have said is that the period of continuous officiation will not be the criteria. Your seniority in the cadre will come according to your roster point. So if a promotee came at roster point 10, then even if I have come in 3 years later, I come in point number 10. And direct recruit comes under point number 11, then even if he has come in 2000, he comes at point number 11. This is the inter se seniority roster which has been, the mechanism has been devised, your lordships, and also has been followed in various rules. Now, the second, another aspect of this, your lordships, is that with regard to LCE particularly, there are 4 judgments I want to show to your lordships, where there have been conflicting aspects which have been considered by lordships, and there is no clarity. Therefore, your lordships will be required to give us clarity as to which of the 3 options is the correct option, which must be followed, which will be the most efficient option, your lordships. So I will just point those 3 judgments out to your lordships. Then comes the aspect, your lordships, within, now these are three categories at the same level. Now, within the promotees itself, what will be the seniority? What will be the basis of seniority? Now, between these 3 categories, your lordships, merit is the basic criteria, is the primary criteria, and that is why it is being incentivized for the LCE category. So when the merit is incentivized, your lordships, how is it incentivized on ground, your lordships? It can be incentivized only by me climbing the ladder higher, faster. But if I take the exam, I do very well in the exam or do badly also, but I clear the exam, your lordships, and I remain at the same position in the promotee list, your lordships, then there is no incentive for me to better my skills, your lordships. And from practical state-wise aspects, I can show to your lordships that promotees who took LCE exam, they are actually coming lower in seniority than higher in seniority. And I'll show from UP, because I'm appearing in the UP matter, your lordships, that they have come down in seniority. So many of them, what your lordships have found, that people are not taking LCE exam. They are not taking it for the purpose, because in promotion, they are rising faster.
But that now we have resolved.
No, your lordships.
Yes, because earlier they could not appear before completion of 10 years.
Correct.
Now we have reduced it to 7 years.
That is one aspect. The second aspect, your lordships, is that despite my being eligible for taking the LCE exam, despite that, your lordships, now age, etc., has been resolved. But where do I fall on the seniority list? I'm still at the bottom of the seniority list. The pool, your lordships, have resolved, that the pool will become bigger.
If somebody, suppose A passes LCD.
Yes, your lordship.
And get promoted in 2020.
Yes.
The juniors will be, who are promoted subsequently from the promoting cadre will be always junior to him.
Your lordships, I'll show from the actual application, your lordships, that is not what is taking place on ground. Your lordships have set it out. Lordships have said that the rules will be formulated. Rules are formulated, but what is happening, your lordships, that the High Court are now using the roster year-wise or recruitment-wise.
This must be happening on account of the perceived strict observance to the roster point. That irrespective of you, as Honorable CJ has pointed out, that irrespective of you qualifying in 2020.
Please, your lordship.
And at, say, particular roster point, say, for example, you are 12.
Yes, your lordship.
And the ordinary promotees, merit cum seniority promotees, if they have a roster point number 10 and 11.
Please, your lordship.
So even if they are promoted in 2023, they are being placed at 10 and 11, and
Please.
resultantly you are stuck at number 12. That might be happening only because of misconstruction or misapplication of the roster.
I'm most grateful, your lordships. That is one of the reasons. And the other reason also, your lordships, is
So most of the cases, the seniority is being roasted by this roster.
your lordships.
Take it back to the date of vacancy.
Your lordships is absolutely right. Why that is happening is because it is controlled, the roster is not controlled as a running account on the basis of cadre strength, but it is controlled by recruitment. So the roster breaks in the first year, suppose there are 20 recruitments, your lordships, after number 20, it restarts from number 1, whereas it has to continue with number 21. So that is where the breakdown is happening, that it is selection wise or year wise that the roster is again put into play. So therefore, lordships will notice that normally in all high courts, I'll show the appendix, in the roster, you have first 3 direct appointments, next 2 promotees, and the last, your lordship, LCA. So, or it varies from different, the numerical or this thing, but usually direct promotee is the number 1 in most of the rosters which have been prescribed. Now, unfortunately, what is happening is that suppose 10 people have been selected in a particular year, your lordships, again direct recruitment come in the roster, higher in the roster, the next selection. So the breakdown is happening at that particular point. The breakdown, it is not that the rule is not providing. The rule is providing, but the way it has been applied, your lordships, at least in Uttar Pradesh, your lordships, is for this reason that it is applied on basis of continuity of service and it is applied selection-wise. It is not applied cadre-wise. Then the last thing that I want to bring your notice and attention to your lordships is, which is where there'll be some guidance which will be required by your lordships, is with regard to the selections which have taken place post 2002. Now, in 2002, your lordships had given them time to implement it, to amend the rules. The rules got amended. But again, our complaint is this, that the rules were not being followed as per the amended aspects, your lordships. So what about the selections which have taken place after 2002? Because in 2002 itself, it was mandated by this honorable court that this will now apply prospectively. Then from 2002 onwards, your lordships, my humble submission is that all selections which have taken place post 2002 have to be in accordance with the guidelines which have been given by your lordships in all India judges and what your lordships will decide today, your lordships. So that date, cutoff date, on basis of which the seniority must be drawn in the cadre, your lordships will have to consider and give that guidance, that what will be the date from which, because your lordships have, in all orders and judgments, even in 2025, your lordships have said that this will apply prospectively, the 25%. Then lordships have also said we'll amend the rules. The shortfall is not amendment of the rules. The shortfall, your lordships, is the application of the rules. Now, your lordships, shortly, I will just point out, if your lordships will just take R.K. Sabharwal for a moment, your lordships. Lordships will find it. Volume.
Volume 5A.
Your lordships, volume 5A, page 360. Lordships, it's a short, concise judgment, which is holding forth even today, your lordships. It has withstood the test of time.
It's 360.
360, your lordships. Volume 5A.
Not the volume you provided just now. No.
No, your lordships, that's 6. That's volume 6.
This is the nodal council.
This is the Nodal Council's volume 5A, your lordships. Yes,
5A, 360.
page 360.
Which judgment?
R.K. Sabharwal, your lordships.
Yes.
Yes.
Now, my submission, your lordships, with regard to R.K. Sabharwal is that, your lordships, this lays good law and it is a 5-judge bench judgment, your lordships, and that must be followed again and has been followed, and there is no cause to differ from this, your lordships. Lordships may kindly come to paragraph number 5. This was with regard to the Punjab Engineering Services, your lordships. And here the dispute was with regard to interstate dispute between promotees and direct recruits.
Yes, yeah.
The lordships have the SCR copies.
Yes.
Yeah. What is this? We are missing considerable force. Your lordships will come to page 369, placitum D.
369.
Please, your lordships.
Well, so I have a suggestion. Volume 3R has the SCC volume of Sabarwal, because I think if Ms. Makhija is referring to para numbers, that may be more helpful. R3.
Thanks. Lordships may, I'm just reading the portion which is relevant. Your Lordships may mark it, it's para 5 in the SCC and it is placitum D at page 44. Internal 44, placitum D
Yes.
in the SCR. We see considerable force in the second contention raised by the Learned Counsel for Petitioners. The reservations provided under the impugned government instructions are to be operated in accordance with the roster to be maintained in each department. The roster is implemented in form of running account from year to year. The purpose for running account is to make sure that SC, ST, and OBCs get their percentage of reserved posts. The concept of running account in the impugned instructions has to be so interpreted that it does not result in excessive reservation. Then your Lordships will skip a bit and come to the middle of the paragraph where it is said, we see no justification. Lordships, then an example is given. And then if your Lordships will come to,
370.
Yes.
yes, your Lordships, page 370 top. We see no justification. We see no justification to operate the roster thereafter. The running account is to operate only till the quota provided under impugned instructions.
This is once that is complete.
Yes.
Then the person, the vacancy filing will be filled in from that category alone.
Please, your Lordships. That is the principle. That's the clear-cut principle. And one more aspect which is clear from here, your Lordships, is whether it has to be according to the post or the vacancy. If your Lordships comes to the last portion of this paragraph, it says, the vacancies arising in the cadre after the initial posts are filled will pose no difficulty as and when there is a vacancy, whether permanent or temporary, in a particular post, the same has to be filled from amongst the category to which the post belonged in the roster. For example, SC persons holding the post at roster point 1715 retire, then these slots are to be filled from amongst the persons belonging to the SCs itself. Similarly, if persons holding the post at point 8 to 14 or 23 to 29 retire from these slots, are to be filled from among the general category. By following this procedure, there shall neither be shortfall nor excess in the percentage of reservation. Then your Lordships, next paragraph is with regard to the basis. What is the total strength on basis of which it will be calculated? It is the cadre strength and not the recruitment strength. The expression posts and vacancies, often used in the executive instructions providing for reservations, are rather problematic. The word post means an appointment, job, or employment, a position in which a person is appointed. Vacancy means an unoccupied post or office. The plain meaning of the two expressions make it clear that there must be a post in existence to enable the vacancy to occur. The cadre strength is always measured by number of posts comprising the cadre. Right to be considered for appointment can only be claimed in respect to a post in a cadre. As a consequence, the percentage of reservation has to be worked out in relation to the number of posts which forms the cadre strength. Now, under the UP rules, your Lordships, the cadre is defined under Rule 2, I think, where it says that the service will be a single cadre called the Higher Judiciary Service cadre. So the cadre is the entry-level post that we are talking about. Then your Lordships, this has been now consistently followed. And if your Lordships will take 3 particular judgments with regard to LCE, where in my humble submission, 2 judgments are in conflict with each other, therefore Lordships will be required to resolve that conflict. Your Lordships will kindly take Punjab and Haryana High Court versus State of Punjab, your Lordships, volume 6, which we've just handed over, your Lordships. At page 288. Lordships, on a lighter side, when I was preparing for this, Your Lordships, Punjab seems to be having the supremacy in service law, Your Lordships. R.K. Sabharwal also, Your Lordships, this judgment also, which is the correct.
By supremacy, why only service law?
Service jurisprudence is all given by Punjab.
Yes, Your Lordships. That,
Why are you leaving Haryana?
Your Lordships, I'm just sharing an observation that I had.
Great problem. You want to conclude?
Yes, Your Lordships.
5 minutes.
was kind permission. It was slated to address the bench on behalf of the ITAT Bar Association. Was in fact that application is slightly different. Because may just detect that the issue seems to be there. The issue what we had flagged in our IA. Although
But that we have, we are.
yes,
getting
that's
Madras-
different. That's what I'm saying.
Madras Bar
Yes, Manoj, that's what I'm saying. Manoj, I don't wish to take Manoj's time on that today. Manoj, may not. That's IA 264842.
Okay, we clear करके वो-
Yes, Manoj. I'm sorry.
We'll tag it with Madras Bar Association. That is kept on, I think, next Monday.
Next Monday, Manoj, third Manoj, the AG. Man. I'm so very good. Manoj, I was serial number 7.
Yeah, so your time is saved.
Yes, Manoj, that's it.
We can rise early today.
Grateful.
My lords, for mentioning, if I may, we have filed an IA for impleadment on behalf of a Pramoti district judge from Kerala. So kindly.
Yeah, Bob?
For a Pramoti district judge from Kerala, my lords. So we have filed on 24.
Yes, we are hearing.
Yes.
Mr. Dwivedi's arguments might take care.
Yes.
Yes, just for mentioning, yes.
Yes, Ms. Pakila.
Please, Your Lordships. Lordships, I was referring to the 2 conflicting judgments on LC matter. Your Lordships may kindly take volume 6, page 288. This is the Punjab and Haryana High Court judgment.
Yes.
Lordships, here the issue was again with regard to the inter se seniority between the 3 categories, Your Lordships. And if Your Lordships just comes to paragraph 2 for a moment. If I can read that, Your Lordships. The questions which have arisen for determination in this batch of appeals relate to inter se seniority dispute between 3 streams of Punjab Superior Judicial Service, that is officers promoted on basis of merit cum seniority 50%, direct recruits 25%, and LCE 25%, Your Lordships. Then Your Lordships will come to para 7, where Rule 12 has been produced. And earlier, Your Lordships, the seniority rule provided from respective dates of their confirmation. If I can just read para 7. Rule 12 dealt with seniority, which provided that seniority inter se of the substantive members of the service, whether direct recruits or promotee officers, shall be determined with reference to respective dates of their confirmation. On 31st December 76, Rule 12 was amended, providing that seniority inter se of members of service will be determined by length of continuous service on the post in the service, irrespective of the date of confirmation. So here the length of service was decided to, was a part of the rule. Then Your Lordships will see issue number 1 is discussed, and Lordships will come to paragraph 44. Lordships, I'll just read this. A 3-judge bench of this court in Srikant Roy versus Jharkhand, while determining question of number of vacancies in respect of LCE exam of Jharkhand, as in Jharkhand Superior Judicial Service, has held that cadre strength is always measured by number of posts comprising the cadre, and the percentage of quota has to be worked out in relation to the number of posts which forms the cadre and has no relevance to the vacancy that would occur. And then the following was laid down in para 24. And Your Lordships will then come to para 48, which is with regard to from what date, Your Lordships, the principle must apply, which Your Lordships I just made a brief reference to with regard to prospective application of the principles of all India judges. If Your Lordships will kindly take para 48. This court in All India Judges case number 3 in para 29 has clearly directed that the system which was directed to be put in place by this court-wide paras 27, 28 and 29 was to apply prospectively. This court had directed that appropriate methods will be adopted by high courts and approved by states wherever necessary by 31st March 2003. Up to 2004, the quota for promotion on basis of merit cum seniority was 75%, Cadre strength as on 13/9/2007 was 89, which was increased in 2007 as 107. After the amendment of the rules in 2004, promotion of 10 officers was made. It is mentioned in Civil Appeal of High Court that the cadre strength of Punjab Superior Judicial Services before 2004 was 88. Thus, in the year 2004, when the cadre strength was 88, 75% posts were to be manned by promotees under merit cum seniority, that is 66 were to be manned by promotee officers. The judgment of this court in All India judges being prospective, the ratio of officers as existing before unamended rules cannot be adversely affected. A promotee before the amendment of 2004 rules who was well within their quota suddenly cannot go out of the quota and become an excess merely on the strength of amendment of rules which are prospective in nature. For determining the quota, the cadre strength which existed prior to amended rules and subsequent to amended rules have to be treated differently. Promotees quota, which was 75% prior to 2004, make 66 posts in their quota as before amendment in 2004, where cadre strength has been increased to 107. 18 posts have been further added to the cadre. This increase having been made after the amendment on cadre strength, the rules as amended will be applied for bifurcation of quota. On 18 newly created posts, 50% comes to 9. For the out-of-turn promotees, 4.5 and direct recruits, 4.5. Thus, promotee officers on or after the increase of cadre will have to be 66 plus 9, that is 75. In the appeal filed by the High Court, it is also indicated that 10 promotees were affected in 2004 under 50% quota of merit cum seniority. Rules providing for 25% quota for out-of-turn promotion being in place, at least few vacancies ought to have been given to the out-of-turn promotees. There is no detail of further information. So, Your Lordships, they have held that from 2002 onwards, whenever the rule was amended, the selections thereafter will have to go by the principles of All India Judges number 3, Your Lordships. So, my humble submission before Your Lordships is that post 2002, state-wise, High Court-wise, Your Lordships, whenever the first recruitment is pursuant to the amended rules, Your Lordships, it has to be, then obviously will have to be seen by the different benches, whether they are in compliance with these principles or whether the rules and All India principles have been violated in the process of selection. Because our complaint before Your Lordships is that our rule provides for a particular aspect, there is an ambiguity with regard to another aspect, and the rule has been wrongly applied in violation of All India 3 judges matter. So our humble submission, Your Lordships, will be that after principles are laid down, then every selection will have to be tested against that. Now, Your Lordships will kindly come to a judgment where the conflict is there, which Your Lordships will find at page 223 of the same volume. This, Your Lordships, pertain to Rajasthan High Court. And in this, Your Lordships, there was a cycle which was given in the Rajasthan rules, which was akin to a roster. But what the Rajasthan High Court was doing, Your Lordships, was placing them en bloc. So if there is a selection of direct recruits, then en bloc, Your Lordships, they would come in that cycle. Then if there is a subsequent or a later selection of LCE, then en bloc, they will come under the direct recruits. Then whenever the selection happens of the promotees, then en bloc, they were brought in. And in my humble submission, Your Lordships, this is in conflict with this principle which has been followed and laid down and approved in this judgment. Your Lordships, is in conflict with all the previous judgments which I have just shown to Your Lordships. And here on this bench, Your Lordships has approved the en bloc aspect. Against the principle, which is very clear, is that wherever the position is, the person will come against the post. So here, Your Lordships, they are coming in order of continuous officiation so as to speak and in length of service, rather than against the post which is marked on the roster. Lordships will kindly come to para 1.1. And your lordships, there was also an aspect of fast track court, the ad hoc judges who were appointed again, the ad hoc posts of fast track courts that your lordships had already held. So it follows Brijmohan Singh saying that as far as that is concerned, seniority cannot be given in the cadre. That has to go according to your parent cadre. So that aspect I'm not touching, your lordships. I'm just touching the aspect with regard to LCA. Writ petition filed by 4 petitioners prays for appropriate directions that after promulgation of Rajasthan Judicial Service Rules 2010, all appointments ought to be in conformity with 2000 rules and allocation of seniority must be in accordance with the cyclic order provided in Schedule 7 to the 2010 rules. In terms of 2010 rules, post of cadre of district judges and higher judicial services in state of Rajasthan was required to be filled up according to All India judges. This writ petition filed by candidates who were successful in LCE prays that they be allocated seniority in terms of the cyclical order in Schedule 7. In this group falls writ petition so-and-so and so-and-so. Then the rules are from paragraph 13 onwards, your lordships, where a combined select list and seniority is given in rule 42 and 47. Lordships will find it under para 13.6. And then your lordships, para 40 onwards. And I will not bother to read much of it. I'll just enunciate the principle which was set out over here in my humble submission, wrongly so, is that they accept the fact that it has to be in cyclical order. But in that cycle, they say you have to place them en bloc according to the selection. So it is not relatable to roster point, but it is relatable to the date of selection. And para 47.3, your lordships, I would like to invite your lordship's attention. In the premise, the conclusion is inescapable that candidates selected through LCE and direct recruitment while order dated 2013 cannot claim to be clubbed, and 47 judicial officers promoted in substantive capacity on 21/4 in accordance with the cyclical order. We accordingly answer question 40.3C and find that 47 judicial officers are rightly placed en bloc senior to the candidates selected through process initiated pursuant to notification of 2011. Then, your lordships, another point which has been discussed over here is that merit is the primary criteria in LCE seniority list. So within the LCE seniority list, this conflict has again arisen, whether it has to be seniority come merit or merit come seniority. And in para 48, in my humble submission, correctly held so, which has also been subsequently held in Lordships 2025 All India Judges Judgment also, that within the LCE group, the list will be made in the order of merit. The persons who have qualified in the...
Yes, whatever is their ranking as per the examination.
But, your lordships, this principle does not apply to the promotees list. That, your lordships, is Justice Pardiwala's judgment, which is the next judgment that I'm citing to lordships. That is Ravi Kumar Dhansuklal. That is, your lordships, at page 982, volume 5A.
Volume?
5A. So I'm just, your lordships, bringing to lordships notice the principles and then how we will consolidate all the principles, your lordships, to come to a, what should one say?
What is the name of the judgment?
Ravi Kumar.
Ravi Kumar Dhansuklal versus
That Gujarat matter.
High Court of Gujarat. Yes, your lordships.
Page 9.
Page 982 of volume 5A.
Last patrol.
9.
Ravi Kumar Dhansuklal Mehta.
Please, your lordship.
Mehta.
Mehta. Now, in this, your lordships, the whole concept of seniority come merit and merit come seniority was discussed, your lordships, in great detail. And here the question that had arisen for lordship's consideration before that bench, your lordship, was that within the seniority list of the promotees, which now is 50%, was earlier 65%, within that list, will the seniority come according to the qualifying exam that they hold, or whether it will come according to their date of officiation? So in this, they have held, your lordships, that the primary criteria in the promotees list, the exam is only a qualifying exam. The exam is not testing your exact merit, but it is only a qualifying exam to take you to the next position. And therefore, here the consideration is of seniority in promotees. Therefore, the person who's senior most, who has qualified, the number of marks will be irrelevant as long as you are above the benchmark of the passing mark.
Cut-off mark, yes.
Yes, your
Well,
lordship.
that's limited competition.
Limited company.
Yes, your lordship. No, this is with regard to promotees, your lordships. Suitability test, I'm grateful.
50%.
Yes,
Suitability
suitability.
test.
Yes, I'm grateful.
But that's for promotees.
Yes, your lordships.
No, not for LCs.
No, this judgment, I'm drawing a distinction with regard to LCA. Within the LCA category, the merit list will be drawn according to the mark.
Marking, yeah, because it's an examination.
Yes,
And so far as promotees are concerned, it is only to find out whether they are suitable. Once they are found suitable, then their seniority would.
Yes, your lordships. Absolutely.
Yes,
So,
so
suitability test is not a test of merit.
it's a test of by finding your fitness.
That's right, your lordships. So that's what has been held in this judgment, and correctly so, your lordships.
This is, I think, considering Gujarat rules.
Yes, your lordships. This is concerning Gujarat rules. But again, in Gujarat rules, your lordships, while this portion has been clarified, however,
I have given some advice also as to what rules should be.
yes, your lordships, because your lordships.
Gujarat, there was no written test for promotion. There was no written test prescribed.
So LCA exam, your lordships, is of 5 papers, which is the same as the direct recruit exam, and it is held simultaneously. It is the same paper, except LCA is exempted from English and general knowledge. For a direct recruit, your lordships, you have to take 3 law papers, English and general knowledge.
Right.
It is the same law exam, your lordships, and your merit list is drawn according to your marks in that examination. But the suitability test is a separate and distinct test.
There was no suitability test in Gujarat
Yes, your
for
lordship.
promotion. I don't know if they have made it now. Till 2021, it was never there.
Well, your lordship, of course, has personal experience.
The court has advised.
To frame that.
Your lordships obviously has first-hand experience. So this is the distinction I'm drawing, that within the category, your lordships also, there is a method in that entire madness, your lordships, which has to be followed. And this judgment, your lordships, was followed also thereafter by Justice Nagaratna and Justice Satish Sharma's bench, your lordships, which your lordships will just note the citation is 2025 6 SCC 460. Lordships will not find it in any of the compilations. It's a recent judgment.
Why do we need that judgment? Only follows it, that's all.
Your lordships, I'm just giving the citation.
Unnecessary adding burden to our.
Now, your lordships, 2 things I just want to show. Lordships had asked for the comparative rules of the various high courts. Just pass these. Just my associates have extracted the relevant rules of various high courts as just illustrative, your lordships. And your lordships, the rules will show the root of the problem that every high court is grappling with. Lordships will recollect the second line of para 27 of All India Judges 3, that there are three streams for this cadre, your lordships, and those three streams, your lordships, promotion,
The
LCE,
officers you are presenting belong to which state?
LCE cadre, your lordships, LCE cadre.
Capital competition.
No, but which state?
Please, to Uttar Pradesh, your lordships.
So let us see Uttar Pradesh rule.
Yes, your lordships, I've extracted these. If your lordship just sees the first serial number itself, it is the Uttar Pradesh rules. Now, your lordships, rule number 6 prescribes the quota, and lordships, all these rules will be prior to the 25 judgments, so they'll all be 10% instead of 20.
So that will have to be changed now.
But that will be changed accordingly. Your lordships, rule 22 is the methodology of appointment. Now, in this, your lordships will see, subject to provisions of sub-rule 2, the governor shall, on receipt from court of the list mentioned in rules 18, 20, and 21, make appointments to the service on occurrence of substantive vacancies by taking candidates from the list in order in which they stand in the respective list in accordance with roster. So this is with regard to the civil judge, how they stand in that roster. Appointments to the service shall be made on the basis of roster system. The first post shall be filled from the list of promotees. Second post shall be filled by direct recruit. Third and fourth post shall be filled up from list of promotees. And fifth post will be filled up by candidates selected strictly on merit through LDCE according to roster as prescribed in Appendix 1, which will cease to become operative on the date of respective three streams achieving their full allotted vacancies. Thereafter, on account of arising of any vacancy in quota of respective stream, the same should be filled up from the stream where the vacancy arises. So here your lordships will see an Appendix 1. Your lordships have produced Appendix 1, the last sheet in this set of papers. Here is a 100-point roster which has been prescribed as per Appendix 1. Then your lordships will see proviso that while following the roster, at no point of time the respective percentage of posts filled from direct recruit and LDCE shall exceed 25% and 10% of the strength of service. In case the percentage is exceeding the allotted quota, in such eventuality, promotee shall occupy the vacancy, which would have gone to direct recruit or LDCE had not the same been in excess of 25% and 10% respectively, either of the two. Again, on the principle to be filled up, the percentage cannot go beyond. So there should not be over-representation or under-representation, so that adjustment is to be made. Now, your lordships, subsection 3 is a little bit of a thing which needs some focus. In the eventuality of delay in making appointment under sub-rule 1, and further if exigency of service so requires, the governor may, in consultation with court, make short-term appointment as a stopgap arrangement from among the promotees in vacancy in those services till appointments are made in sub-rule 1 and 2. Provided that period of service spent by promotees on short-term appointment to service as stopgap arrangement shall not be computed under Rule 26. So seniority will not be computed by officer. It will be computed according to your number on the roster. Rule 26, your lordships, deals with seniority. Seniority of officers appointed in the service, here it is AJS service, shall be determined in accordance with the order of appointment in service under sub-rule 1 and 2 of sub-rule 22 of these rules. Seniority of members of service who have been confirmed in the service prior to commencement of these rules shall be as has been determined by the order of government as amended from time to time. Now, your lordships, this rule is perfect on paper, but in application, and I will show from my application, the manner in which it is being applied is that instead of the roster starting as a running account, unfortunately, it is being applied selection to selection. So instead of cadre, the roster should be strictly applied to the cadre, but it is being applied to selections. So that is the reason why this anomaly is existing. if the roster is strictly followed, which your lordships have said in the Gujarat judgment, that it must be strictly followed in accordance with all India judges, then that anomaly would not arise. And I can directly, your lordship, show that if your lordship takes my written submission, volume 6.
Why we are not considering individual seniority?
Yes, your lordships. I'm
Presenting 2-3 officers, we don't know how many officers you want.
Yes, your lordship. So only by way of example, as a
It's
principle.
only our general principle that what
Yes.
should be the.
My petition in the High Court, which was considered and dismissed, they have filed an SLP which is pending before Justice Datta, Pankaj Datta. So now they are raising all of these issues.
No, I'm not raising, I'm showing by example, your lordships. I'm not raising that
You
issue.
can say
I'm
rule is
stating,
bad, you can say rule is bad, or you can say rule is good, it should be followed on a uniform basis.
yes, your
But
lordship.
how the rule has been interpreted in a particular case, or how the High Court has determined that, we can't go into individual High Court's claims.
Now, your lordships, in accordance with the 25 judgment, the only High Court which has come with the 10% with regard to civil judges, your lordships, is Bihar. And they have notified these, your lordships, in, I think, 4th of October 2025. At number 2, your lordships have extracted these rules. And the point I'm drawing your lordship's attention to is the proviso, which says that the date of appointment and officiation will not be the determining factor. On that aspect, most of the rules are silent. So therefore, the high courts are applying them in different ways. And in comparison, your lordships may see at number 3, West Bengal rules. And rule 26(2). I'm sorry, rule 31 regarding seniority is with the method that is provided is continuous officiation. So there is great variety and variation amongst all the high courts. And in my humble submission, your lordships, this uniformity is the guidance which your lordships, we desire from your lordships. Just one more aspect, your lordships, I wanted to point out to your lordships is with regard to the All India Judges 25 judgment. Your lordships may find that at volume 5A, page 873. Because in my humble submission, your lordships, the 25 judgment reiterates each and every principle which I have just placed before your lordships. The only change being the numerical aspect and introduction of LCE with regard to civil judges, 10%. Your lordships, the conclusions in para 89. And each one of them are important, your lordships, because each one of them is with regard to every aspect. May I just read para 85, sub-para 1. In view of the above discussion, we issue the following.
903.
I'm sorry. Page 903, your lordships, 903. Volume 5. Please, your lordships. Para 89.
Yes.
In view of the above aforesaid discussion, we issue the following directions. Number one, all the high courts and state governments in the country shall amend the relevant service routes to the effect that the quota for reservation of LDCE for promotion from cadre of civil judge senior division to higher judicial service is increased to 25%. So, your lordships, in conclusion, from 2002 to 2010, which is when Justice Balakrishnan's judgment came, the quota was 25. From 2010 to 2025, the numerical will change to 10%. Prior to 2002 to 2010, the numerical remains, to 2010 to 2025, numerical remains 25 and will now continue to be 25. Number two, all the high courts and the state governments in this country shall amend the relevant service rules to the effect that the minimum qualifying service required to appear is 3 years. So now, your lordships, that qualifying service aspect. Number three, your lordships have introduced 10% LCE with regard to civil judge, senior division. And in my humble submission, this will also take color from how the LCE of 25% is affected, your lordships. So the manner in which LCE of 25% with regard to district judges is affected, the same way the LCE with regard to civil judges will be affected. Then, your lordships, number 4 is a little significant. Needless to say that if any post reserved for LDC for either civil judge of or of the higher judiciary remains vacant, the same shall be filled through regular promotion on on basis of merit cum seniority in that particular year. Filling up the vacant post in the ratio considered for LDCE will have to be carried out from simultaneous selection process carried out for regular promotions in the same year. This might need a little clarification, your lordships, because this is now with regard to vacancy. So, in compliance with Mazhar Malik, lordships have said that every year all the vacancies must be completed. So if you don't find sufficient number of LCE candidates, then you fill it up by regular promotees. But your lordships, the seniority list will not be affected by this. So even if a promotee has come up earlier because no LCE 25% were there, your lordships, then the seniority will be worked out according to the roster point again. So a promotee which has come in, say in 2010, because 10% LCE persons were not there, only say 3% came in. Then 7% had to be filled up by promotees. But the seniority, your lordships, the person who comes in the next selection in LCE will go higher than the promotee, because the roster point is higher.
No, but then you are arguing contrary to what Mr. Dwivedi just now argued.
Your lordships, that's the dichotomy between the promotees and the LCE persons, because promotees are saying club us all together. So whether an LCE, and that is the whole disincentive aspect. As far as an LCE is concerned, your lordships, if I am coming in the order as a promotee.
So you want a total separate cadre of LC?
It is already provided.
Whichever year you are selected, you will get into that position. How can you jump over all those who have been promoted earlier?
I'm just explaining, your lordships. Here,
Clearly, because in the previous year, LC quota was not filled up.
Yes, your lordships. Then
the full extent.
Because, your lordships, if I'm coming along with my promotees, suppose my promotion is happening along with, in the same order, your lordships, then I don't even have a jump.
Then it's different. But somebody who was promoted previous year and regular promotion, you
don't have a jump because you did not clear it earlier.
No, your lordships, that's the problem. The problem is this: the incentive. What is the incentive which lordship provides? The incentive that lordship has provided.
Incentive is that with the lesser number of years, you are now in the high judicial service.
That's why I wanted to show my selection list of LC.
We are not going to the facts of the thing.
I'm putting that aspect before your lordships, because in fact, this does not happen, and the numbers and the data have established that the LCE persons are not going higher in seniority. They are still coming behind the promotees. And in fact, if I'm coming...
If that would have been so, then they would not even opt for going to LCD. If they are going below the regular promotees, Why would a person go and opt for the examination?
The aspect that I'm clarifying here, your lordships, is that suppose it is a 2010 vacancy.
There are four more councils up to you.
Your lordships, this is a little tricky aspect, so just 2 minutes I'll take on it. If it is a 2010 vacancy, your lordships, so, and 10% LCE vacancies and 50% promote vacancies. Now, LCE, your lordships, 10% don't get selected in 2010. Only 2% get selected. Then when the next selection takes place, say in 2012, and an LCE gets selected, your lordships, so that LCE will still steal a march over the promotees, will have to come higher than the promotees. This is what I'm saying.
So irrespective of the promotees having been promoted earlier, you want a notion, you want a seniority to be given to you above them.
Your lordships, according to the roster post. Because if in the roster, if your lordship.
So we, in a nutshell, Mr. Dwivedi opposes the roster system. He says that the roster has to come to an end at the end of the
Yes, your
process.
lordships.
And you are supporting the roster
Running
system.
account,
Yeah.
which
So you want it to
Sabharwal
continue endlessly.
Your lordships, that's what Sabharwal says. Sabharwal, which has been consistently followed, says whenever there is a debit, then you credit it from that category. What is the
So
point?
suppose a person who is promoted 3 years earlier
Yes, your
as
lordship.
a district judge
Yes, your lordships.
on account of his seniority.
Yes,
And if you get selected through LCD,
yes, your lordship.
LDC,
Yes.
then you will be shown senior to him, though he has more.
Really, because that roster point was left vacant at that time. No, you can't.
That is only my incentive. Otherwise, then I'll come by promotion. That is what the whole thing is. If your lordships will just give me a second and lordships will see this roster for a moment. Just to explain it, your lordships. Lordship sees that the first is a promotee, next is a direct recruit, 2 promotees, and then LDCE. Now, suppose the LDCE post doesn't get.
That is where all selections are taking place at the same time and they are coming, this is how it will be filled up.
Please.
But if you are coming subsequently after 3 years, 4 years or 2 years,
Please, your lordship.
then you are there to fill up that post, but you cannot get that seniority.
Because
Fall in that LCD quota, only if the quota is available, posts are vacant for LCD, you can be taken up. But you cannot get that seniority, backdated seniority, no?
if your lordship sees that suppose this LDCE post is not filled up. Suppose in this selection, this doesn't get filled up. So lordships have said that the vacancy should be filled up by a promotee.
Correct.
So does that promotee steal a march over the other persons? He then
So
steals a
when he's
march.
filling a march, he comes through regular
promotion.
Your lordships, then again the same thing is happening.
But this appears to be totally hypothetical because nobody, if you are in a normal mode of promotion, is entitled to be there. Why would you go for LTC, prepare for the examination, do study?
Precisely, that is the point I'm saying, your lordships. If I'm not getting a high,
Anyway, madam, it's.
if I'm not getting high seniority, what's my?
We will examine your.
Don't appear for that.
That's why your lordships, people were not appearing, though lordships.
No. People were not appearing because they would otherwise be promoted in the normal course by the time they were entitled for, they are eligible for LDC.
Please.
Therefore, we reduced that 10 years to 7 years.
Pointing out, there are 2 aspects. One is increase of the pool. There was not a sufficient pool for persons to take the exam.
Now there is.
Now there is, your
Then your argument is totally contrary.
No.
You are saying that there were not a sufficient pool. And then you are also saying that out of 10% only 3 posts were filled and 7 were vacant.
No, your lordships, for the reason that people did not qualify. So the people who have qualified must be.
Anyway, you must give time to others also.
Yes, your lordship. So that is the point that I'm making. And your lordships, with regard to the rest of the 3 points in the 25 judgment, your lordships,
There are 5 more councils.
Yes, your lordships. So
You are almost taken an hour, more than an hour.
yes, your lordships. And then on the prospectivity aspect, which I've just explained to your lordships, that from which date the selections have to be considered, your lordships. Grateful. Yeah, just shifted on that side.
May it please you, Lord. I beg to appear for the Kerala High Court. I am not getting into, my Lord, the manner in which the LC will have to be promoted, the date on which they should be assigned seniority, or the promotees will have to be. Question which has been referred to your lordships is only this. Therefore, I make limited submissions, my lord. The High Court cannot be seen as taking sides with one group or the other, and I have not done so in my written submissions also. That's why, my lord, I preferred to, though in the sequence, my lord, I had to come immediately after the amicus. I thought, let the contesting parties, my lord, make their submissions. And I will only place before your lordships, my lord, where probably the High Court could do with some guidance from your lordships court in this. What should be the criteria for determining seniority in the cadre of higher judicial service? My lord, the rules have been placed on record. And the rules, my lord, your lordships get it at it. It's at 105.
Volume 5.
Volume?
It's a volume 4A.
My lords, our written submissions of the High Court starts at page 100 of volume 1. I have given a point-wise submission at page 101. It starts at page 100. At 101, my lord, I have given a point-wise submissions. My lord, the legal submissions have been given at page 102. I'll just take your lordships to
page 102.
but give the rules. The rules are at volume 3A. But if your lordships have the affidavit filed by the High Court earlier, in IA 230675 of 25.
So the rules are at page 418 of the compilation, volume 4A, 418.
Volume 4A, page 418.
Volume 4A, page
418. Got it. My lord, rule 1.3.
418. It is PDF page 428.
PDF page number.
PDF
PDF
page 428.
page 428.
PDF page is 428.
428. My lords got it. My lord, rule 1.3, 15% of the posts in the service shall be in super time scale and 35% of the posts in the service shall be selection grade. My lord,
You are reading rule 1.3.
sorry.
Rule 2.1.
2.1.
Rule 1, sub rule 3.
Huh? Rule 1, sub rule 3.
Sub rule 3.
15% of posts.
Yes, my lord. 15% of the posts in the service shall be in super time scale and 35% of the posts in the service shall be in selection grade. Now, if your lordships kindly come to next page, sub rule 2 of rule 2.
Appointment to 35%.
Appointment to 35% selection grade posts in the service shall be made by the High Court with effect from 1st of January 20 from amongst the members of the service on the basis of merit and ability. Seniority being considered only where merit and ability are equal. Only approved probationers with 5-year service shall be eligible for being considered for promotion to the selection grade. Appointment to 15% super time scale posts in the service shall be made by the High Court with effect from 1st of January 20 from amongst the members of the service holding selection grade posts on the basis of merit and ability, seniority being considered only where merit and ability are equal. No person promoted to selection grade shall be eligible for appointment to super time scale unless he has completed 3 years in selection grade. And then, my lords, the Rule 5, appointing authority. 5.1, all appointments to the service referred to in item A, B, and C of sub-rule 1 of Rule 2, which is, my lord, that 50%, 25%, and now 25% recruitment to the higher judicial service shall be made by the governor in consultation with the High Court. Therefore, the High Court conducts the selection, and then, my lord, the order of appointment is issued by the governor. Then 2, all appointments to the selection grade and super time scale posts shall be made by the High Court. Therefore, my lord, once you are in service, then, my lord, the question of appointment to selection grade and super time scale, which is, my lord, the same higher judicial service itself, is made by the High Court. Rule 3, my lord, captures the roster system. Appointments to the service shall be made on basis of roster system. The first post shall be filled from the list of promotees. Second post shall be filled by direct recruitment. Third and fourth from the list of promotees. And fifth post shall be filled by the candidate selected strictly on merit through limited competitive examination and so on, according to the roster as prescribed in the appendix. I've given the appendix, my lord, it's a 40-point roster. To these rules which will cease to operate on the day the respective 3 streams achieve their full allotted vacancies. Therefore, on account of arising any vacancy in the quota of the respective stream, the same shall be filled from the same stream of which vacancies arise, provided that while following the roster, at no point of time the respective percentage of posts filled by direct recruitment in limited competitive examination shall exceed 25% and 10%. Now it must be 25% and 25% of the cadre strength of service. In case a percentage is exceeding the allotted quota, the promotee shall occupy the vacancy which would have gone to the direct recruit or limited competitive examination. My lord, the rules do not provide for a post of principal district judge. And therefore, my lord, I have made it clear in my affidavit and the written submissions that is an administrative assignment of work and fixation and by the High Court. Generally, my lord, though ability is also taken into account, seniority is also taken into account, and therefore, my lord, one amongst the district judges will have to be posted as a principal district judge. Generally, my lord, it goes by the seniority also, but ability and merit are also looked into. And, my lord, the one question on which, my lord, we have tried to make a submission is this: when it comes to the question of assignment of seniority amongst the district judges in the higher judicial service, which is a question, my lord, which your lordships are grappling with. My lord, promotees come in, LCE comes in. Direct recruitment, my lord, is supposed to be made every year. But as your lordships would have noted, and your lordships would have observed, my lord, innumerable times with your lordship's rich experience, it would have been very good, my lord, if the direct recruitment takes place every year, depending upon the number of vacancies which are notified. But the selection starts from the 1st of January. But unfortunately, my lord, more often than not, my lord, it gets grappled in either some litigation or, my lord, the selection gets dragged along, with the net result that the vacancies which are to be filled up by direct recruitment in a particular year, for example, 23, may get filled up only in the year 24. My lord, it has happened in the Kerala High Court, my lord, more than once. And the matter has reached up to this honorable court also, my lord. I also had occasion to appear for the High Court in more than one case. But point is this, my lord. Therefore, this 25%, my lord, vacancies in the post of district judges in the higher judicial service, which has to be filled up by direct recruitment, may not get filled up, my lord, in the same year, calendar year as such. But vacancies, my lord, in the post of vacancies which have to be filled up by promotees and LDC, my lord, in Kerala, more often than not, we actually get enough number of candidates, my lord, to fill up the 10% and fill up the 25% and definitely the 10%. That has hitherto, my lord, been the experience. Now, my lord, once they come in, now, my lord, the question of seniority, interstate seniority amongst them, suppose we go by the principle that it is from the date on which they come into the cadre, then, my lord, there cannot be any confusion regarding that. But what happens, my lord, in a case where direct recruits who are recruited against vacancies that are notified in 22 actually come into the service in 23? or actually are appointed in 23, do they get seniority from 22 or do they get seniority only from 23? One. Secondly, my lord, insofar as promotees are concerned, it can happen the other way also. Promotees are concerned, my lord. If promotions are delayed for one reason or the other, and promotions, my lord, the vacancies that arisen in 22, but the promotees are actually, they enter the cadre, they are appointed only in 23. Do they go by the date on which, my lord, the vacancies had arisen? It happens, my lord, in the case of LDC. Now, my lord, one aspect, my lord, on which we have made a submission, and I confine myself only to that. My lord, see, higher judicial service, my lord, discharge of duties among in the higher judicial service, my lord, would take in not only judicial discharge of judicial functions, but it also, my lord, concerns itself with certain categories of certain aspects of administrative experience as well. My lord, if one is being if somebody, my lord, in the higher judicial service is being groomed for higher duties as such, therefore, my lord, there is a legitimate aspiration that is felt by the members of the higher judicial service. And there's nothing wrong in that. My lord, the recent judgment whereby your lordships have reviewed Dheeraj Moore, that is Rajanish, what your lordships have said is that 1 year of, or 4 years, 1 year of judicial service or experience, my lord, which a person acquires, my lord, after serving as a civil judge junior division or a civil judge junior division, senior division, can be taken into account for multiple years, my lord, of bar experience for the purpose of calculating the requisite years of service under 233. Principle would apply. Even when it comes to the question of, my lord, assignment of seniority inter se amongst the members of the judicial service. My lord, this, my lord, I say, my lord, with great respect, from the context of, from the perspective of the High Court, my lord, when we have to consider as a High Court, my lord, on the administrative side, we also consider, my lord, how to place persons who have, those persons, my lord, who have rendered, say, 15 years, 20 years, or 25 years. This is not for the purpose of creating a cadre in the cadre. That is not what is contemplated, and then rules do not provide for anything. But in posting a person as a principal district judge or assigning him seniority, my lord, for higher functions as such, without there being any support from the statutory rules as such, and the rules, my lord, are a product of successive directions that your lordships have issued in the All India Judges Association case, and in some cases, my lord, in Malik Mazhar also. Would your lordships consider it appropriate to give guidelines as to whether it is permissible for the High Court to say that after persons have come, my lord, into the higher judicial service, that some weightage could be given to those persons who have rendered, my lord, service in the subordinate judiciary for 15 years, 20 years, or whatever it is. Some weightage could be given over and above, my lord, the roster which is reflected, my lord, in 5.3, which your lordships have seen. My lord, 5.3, the roster, and this, my lord, we say with some trepidation that it has not been possible, my lord, for uniformly implementing the roster over these years, though it has been introduced, my lord, in 2020. That's a default. But that is how it has happened. Therefore, to some extent, if your lordships find it permissible, that some weightage could be given to length of service by, or, my lord, rendered by promotees, then, my lord, your lordships could direct the High Court, your lordships could direct all the High Courts, my lord, across the board to consider whether it could be taken into account. It should be left to the discretion of the High Court, my lord, on the question of assessment of merit and suitability. But when it comes to the question of, my lord, there could be an objective criteria that is drawn up for the purpose of giving a weightage on for service rendered by them, my lord, the service rendered prior to coming into the higher judicial service. It is not to create the cadre. It is only to see, my lord, that rich experience that these persons have gained do not go unnoticed. And this is for the simple reason that generally persons in the age group of 35 to 37 become district judges, my lord, on direct recruitment. LDC, my lord, probably stands on a slightly different footing. But promotees are concerned, even when they start service now, my lord, during the last few years at the age of 23 or 24, because an bar experience is not considered to be mandatory. Even then, my lord, persons get into civil judicial service round about the age of 28, 29, 30. That is how it happened, my lord, when there is high competition that is felt at the stage of recruitment into the entry cadre. And definitely, my lord, they could come into the higher judicial service only, and that's what, my lord, we have stated in the affidavit, around the age of 48. Whereas in the case of direct recruitment, the average age is 42. And therefore, my lord, as an administrative institution,
Average age is 42, entry point.
entry point, direct recruits, average age for direct recruits. The other one is 48. I put it on affidavit also. This is the data, my lord, that we have compiled, and this is the data that we have placed before your lordship. Average, my lord, age during the last 5 years. Principal district judge is not a post, my lord, which is covered by the rules, but it is required. And therefore, my lord, when we choose that, we normally, therefore, we go by the seniority. If merit and suitability, my lord, are equal as such. Therefore, we go by seniority. But in that, is it possible, my lord, that your lordships could lay down some guidelines which would still, my lord, retain with the High Court a modicum of discretion, my lord, in the question of giving some weightage to those persons, my lord, who have come through the promotee channel when it comes to the question of assignment of responsibilities as a principal district judge. This is all, my lord, what we have sought for some guidance from your lordships. And my lord, one submission is, none of the judgments, my lord, of this honorable court say that a valid criteria cannot be adopted for the purpose of, my lord, assignment of an advantage, my lord, or an advantage to a person, my lord, within the cadre. For example, my lord, higher educational qualification can be taken note of in Khosla's judgment. It has been mentioned. Cannot be, in such circumstances, it is found to be not violative of 14 and 16. Lengthier service, my lord, in judicial service can also therefore be taken note of for the purpose of giving some weightage, my lord, in accordance with objective criteria. If your lordships lay down that principle, and that is, my lord, an answer to the question that is referred to your lordships, it would not in any manner violate 14 and 16. None of the judgments of this honorable court would say that that would amount to a creation of a cadre within the cadre. No, that is not what it is meant for. It is not for the purpose of, my lord, creating a sub-cadre. It is only for the purpose of, my lord, taking note of a valid criteria for the purpose of assigning seniority within the high judicial service. Because anyway, my lord, it is not on seniority that elevation, my lord, to the High Court is determined on. Therefore, it's only for the purpose of determining whether a higher responsibility can be assigned to those persons who are serving in the higher judicial service, namely, my lord, principal district judge, essentially, of a selection grade, of a super time scale as such. My lord, it is only for that purpose, my lord, that we have ventured to make the submissions before your lordships, my lord. We obviously cannot say that this should be giving an advantage, my lord, either to the promotees or to the direct recruits or to the LDCs as such. My written submissions are also confined only to that. Great.
The advantage of coming, my lord, in the end is that, my lord, most of what I had to argue has already been argued. And therefore, my lord, I'll limit my submission, my lords. I, my lords, appear for the promotees, my lords, in the state of Punjab. That's the category, my lord, that I represent. And my lord, just like the amicus curiae, my lords, had given 3 alternative suggestions, my lord. One is, my lord, he said parallel stream. Second, he said weightage. And my lord, third he said was reservation of 50-50, my lord. My lord, we don't agree with that, my lords, 50-50 reservation, my lord. The lordships have already, my lords, in the third All India case said 75, 25, 25. It got reduced to 65, but now it's restored to 75, 25, 25. Therefore, my lords, I'll cut short my submission, my lords. As far as weightage is concerned, my lord, I adopt the submission made by the amicus curiae as well as what Mr. Giri has said right now. Weightage, my lord, we are agreeable formula, because that will at least allow us some better opportunities at the time when the promotion happens. My lord. The second, my lord, submission which I make is that there could possibly be 3 parallel streams. One stream for 75%, one stream for 25%, and one stream for 50%, 25%, and 25%. 3 parallel streams, my lords. And all of those streams, my lords, the inter se seniority of the persons in those streams, my lords, should be maintained separately, my lords. And my lord, they will compete at the time when they will actually just come into the zone of consideration based on their inter se seniority. And out of the persons in the zone of consideration, each one of the lists, my lords, whoever is appointed in accordance with the rules, my lords, will go. Lord, that is the submission that I'm making. Lord, I have filed a written submission. Lords, PDF 113. PDF 113. My lordship has the physical paper book. Page 3 of
Arguments.
Page 113, my lord.
111.
111 is my written submission. At 113.
You want to read at 113? Yes.
Yes, I want to read at 113, para 8.
Table 2.
Table 2. Because it shows the poor representation of promotees as compared to their total induction strength.
160 only 11. Table 1.
You can understand this.
To review the earlier judgment.
Lord, I'm not asking your lordships to review the earlier judgment. Lord, to the extent of para 20, para 29, yes, my lord. To that extent, yes, my lord.
That's why we are indicating.
Correct, my lord. To that extent, yes. But my lord, your lordship sees, my lord, para 8. The total strength is 202 of the out of that, my lords, 160 are promotees. I put that in a table, my lords. And my lords, in the top 30 bracket, only 11 managed to get through, my lords. As against 160, which works out to 6.87%. And direct recruits, total strength is 37, out of which 12 managed to get through, which is 32.4%. And out of turn promotion, my lords, 5 out of 5, so 100%. Lord, I'm told, my lord, that in the last 14 years, my lord, there's been no out of turn promotion. The reason may be, as their lordship said, my lord, they may be thinking that they will get the promotion faster in the normal stream. That may be the reason, my lord. But out of turn promotions have not been there. And if your lordships also sees, my lord, table 1, which is at para 6 in the earlier page. This is a projection. Today and in 2026 up to 2029. Now the projection shows that promotee judges will be 11, out of turn will be 5, and direct will be 14. So therefore, my lords, and by 2029, the promotee judges get reduced to 11, out of turn promotee judges gets reduced to 1, and direct recruits gets reduced to 22. Lord, I am showing that table, my lords. Even a future projection, today 11 promotee judges, by 2029 it's reduced to 7, And out of turn promotees, 5 gets reduced to 1, and direct recruits 14 has increased to 22 by 2029. So, Lord, this disparity, my lord, has not been considered by the 2002 judgment, and therefore, my lord, I'm asking your lordships to reconsider that para 29. My lords. Now, my lords, if your lordships also sees, my lord, the propositions that I have, suggestions that I have made, I have summarized them at page 46, para 47.
Interest 37 is page PDF 119 and printed 117.
There are 3 models. Which is the page? Page 7. I'm sorry, my lords. Page 11, PDF 117.
Yes. Solution suggested by applicant.
That's right. Correct.
Basically saying the same thing what the amicus was saying.
Yes. And as far as the weightage is concerned, same submission as Mr. Giri, my lord. I'll skip my detailed submission. I'll just come to what is the para number? The lordship sees para 37, benefits of the first model, which means 3 parallel streams. Age-related disadvantage stands automatically redressed as neither stream can encroach upon the legitimate share of the other in any circumstances. It shall ensure that best of both streams occupy leadership roles, and each stream as a class receives fair and equitable representation in accordance with the intended policy. This model also overcomes all recruitment-related challenges, including administrative delays in filling up posts and ill effect of block filling of multiple posts in a single year, thereby preventing any distortion in seniority or imbalance. Entrants of each stream will have absolute clarity and certainty regarding their future career prospects from the very inception. Model will be eliminating all litigation trends normally possible between 2 streams. Even randomness in the seniority process where unintended benefit accrues is likely to be eradicated. Now, second model, that is weightage. Another fairly workable model to overcome age imbalance challenge worth consideration would be the weightage formula of past service suggested by Shetty Commission. This honorable court may appreciate that this system is still in force and functioning effectively in IAS service, successfully neutralizing any age-related advantage. This hybrid model perfectly fits into Prayer CF amicus with a possible solution, as it also applies rota and quota rule in addition to.
Yes, we'll go through it, Mr.
Very well, very well. There's just one other data, my lord, which the amicus himself had produced as far as Punjab is concerned. I'll just show those 2 pages. That's all, my lord. Volume 1 में क्या है? In fact, the amicus had read it, my lords. Amicus is volume 1.
Same volume 1.
Page,
it starts from page 1, sir.
And
to
page 15. Page 15 of volume 1. Para 23. Yes.
So this table is page 617.
Page 15 of volume
17. 17.
17.
Para 23. PDF 19.
Yes. Table is there.
Table is, I am just showing item number 9, Punjab. Average age at the time of appointment of district judge is 40. At the time of appointment of promotee judge is 46. And the difference is 6 years. So even the amicus has highlighted.
Learned amicus has given the data of
all the data has been given. And that includes data of Punjab. I'm obliged.
Thank you.
Keep it.
Yes, Mr. Dharekar.
The State Judges Association.
Yes.
This association represents all the three classes of district judges.
All the three classes.
Promoted. But we are taking
Yes,
a balanced
association is
approach.
all the three classes of judges.
Yes, my lord.
Direct of.
But we are taking a very balanced approach, which would be in
Obviously,
the best
yeah,
interest of
50%
administration of
people
justice, which would be in the best interest of administration of justice, which would go to eliminate my lord disparities, remove discrimination.
Is Mr. Gumra still the president?
No, it's Mr. Patil. Sachin Patil is the president. Recently, there were elections 2 years back. The stand of the association is how best discrimination can be removed.
So what are your suggestions? You are saying that you are most balanced approach. So what is the balanced
I'll
approach?
first, my lords, placed on record, my lords, certain data in a tabular form. First, my eye is, my lords, at volume 3, page 55. It's in volume 3, page 55 to 88.
No, your written submissions are in volume 1 only.
Yes, written submissions are there, but before that, my lords, I'll point out, my lords, some official data
Achha.
to show that how this, my lords, roster system does not work well.
Yes. PDF page 89.
Let's kindly turn to my lords, page 89. PDF 94.
Volume 3A.
Yes, sir. P4, my lords, annexure P4. Page 83, my lords.
PDF page 89.
IA number? Yes.
Sir, IA number?
IA number, my lords,
248309.
248349.
8309.
49. 248349. There are two IAs, one for intervention, one for
Yes.
Two, 4, 8, 3, 4, 9.
Lords, it is annexure P4.
Yes.
Lords, this is a list of, my lords, 19 judges of the Bombay High Court who are elevated after 2020.
Page number?
My lords, 89.
112, PDF 118.
180.
The IA starts at 248,309.
Its title is, my lords, annexure P4.
Yes. Annexure P4, page 83.
Printed 112.
PDF page.
PDF 118, ma'am. PDF 118.
IA starts.
It is a two.
No, 89 is their list, annexure P4.
IA starts at page 55 of the.
और running page 83 है, PDF page 89.
The confusion would be, I have filed two IA. Lords, I'm referring to, my lords, IA 248349.
Yes, we have that at page 83.
Yes, ma'am. Its title is annexure P4. A list of, my lords,
High Court judges.
yes, my lords, which are elevated after 2020. My lords, out of 19, my lords, judges, serial number 1, 2, and 10.
Yeah.
Serial number 1, 2, and 10,
Still none then.
they are retired, my lords.
All three of them are retired now.
Yes, my lords. So, and thereafter, my lords, during last 5 years, today, whatever 16 judges we have from this category, they all belong to, my lords, direct district judges category. They are drawn from direct district judges category. And then, my lords, may kindly turn to next page. That's 1, 2, and 11, they are retired. So these are 16, my lords, who were drawn from direct district judges. The next page is my lords 3, which are again retired. They were drawn from promoted district judges cadre. Would my lords kindly turn to my lords earlier annexure P3. My lords turn to page 83.
Oh,
My lords, page 83.
no, director also retired, Mr. Mere has retired,
Yes.
Mr. Sanap has retired.
Yes. So today there is no, my lords, judge on the bench who is drawn from my lords promoted district judges cadre.
So therefore, what is your suggestion? You say that you have some balanced approach.
No, my lords, kindly turn to my lords page 83. And this say, I have taken it from my lords official website of the High Court.
We know that, and at least insofar as I am concerned, I know what is actually positioned there.
Lords, I have
What
taken.
you are saying that you are appearing for all the three,
Three categories.
I am not taking partisan approach.
So therefore, what is your suggestion?
My suggestion, I'll come to suggestion. Before that, I just want to point out, my lords, a list of my lords district judges which are there on 1st January 2025. First, my lords 25, they are all my lords from
the district judges.
direct
From
district
the
judges cadre.
Yes.
So tomorrow, if my lords post are to be filled in, my lords, not a single candidate from my lords promoted district judges cadre will be considered. Because my lord, the zone of consideration, they consider 1:3. So today there are, my lords, about 9 vacancies, my lords, in district judges cadre, who can be, my lords, elevated. Now, even if those 9 are to be filled in today, my lords, they are to be filled in from the zone of consideration. And first 27 candidates, they are all, my lords, direct district judges. Kindly turn to my lords page 83. I'll point out. 78, I'm sorry.
79, 78. For first,
My lords, all these
25 are-
23 and even 24 and 25, they're all, my lords, direct district judges. And then, my lords, even on the next page, and by the time, my lords, the earlier list is exhausted and the other candidates are come in the zone of consideration, all these, my lords, promoted district judges, they'll retire by that time. And they'll be only, my lord, direct district judges. So, my lords, elevations hereinafter, even in future, would be done only from direct district judges, my lords, cadre. And this is how, my lord, this is working to disadvantage. And then, my lords, page, my lords, 82, 82, page 82. Lords, out of 125, first 125, we have about, my lords, 525 district judges in Maharashtra. I have taken, my lords, only first 125. Out of 125, my lords, 74 belong to direct district judges cadre, and 51 would be from promoted district judges cadre. And even these 51, by the time their turn comes, they must have retired. So, my lords, only direct district judges would be available for consideration, or they would come in the zone of consideration. This is how it works to the, my lords, disadvantage of. Then, my lords, my written submissions are in volume 1, page 120. Once I'll come to the, my lords, suggestions. My lord, they are at page 13. I'll first, my lords, point out, my lord, 2-3 charts. The first chart is, my lords, at page 122, volume 1. My written submission start at page 120.
The written submission just start at 122.
Its PDF page is 122. Starts it. I've compiled, my lord, the data and put it in a tabular form. That's in 2021. Lords, 6 judges were elevated from district judges cadre. All 6.
That is
Lord,
the page number?
122.
Page ke baad ye.
PDF page 122.
It's a table, my lords, colored.
Giving the average age. The average age.
No, it's not average age, my lord. This is about, my lords, from elevation of High Court judges. Colored, my lords, table.
Colored chart. Yes.
In 2021, my
2020.
lords, 6 judges were elevated, and they all belong to, my lords, direct district judges cadre. Then, my lords, in 2022, my lords, 2 on the first page.
We understand this position. You have already pointed out this at page 83 of the IA. You say that you are applying for all the 3 categories. So what is your solution?
The solution is, my lords, if we have to improve the efficiency of judicial administration, solution would be, my lords, we'll have to give, my lords, adequate representation to the, my lords, promoted district judges.
Yes.
My lords, my suggestions are, my lords, kindly turn to, my lords, page 13. This is
The way forward.
PDF
Yes.
132, my lords, PDF 132.
The way forward.
My lords, before way forward, my lords, there is need to review All India Judges Case 2002. I'll read just one paragraph, my lord. The Honorable Court in All India Judges Association had prescribed the roster system, hoping against hope that the problem faced by the district judges would stand alleviated. However, since the roster system has been ineffective in addressing the problems of disparity between the promotions and direct recruits, it would be necessary to review the procedure of fixing inter-se seniority and quotas for further promotion. If necessary, by reviewing the judgment, the case of All India Judges Association. Third, in the light of directions contained in 1993-4 SEC, my lords, All India Judges Association 2, there was a direction that there has to be periodical review of service conditions of, my lord, district judges. Now, this was done in 1999, and that was considered, my lords, in 2002. Most of the recommendations were accepted, approved. Some recommendations were disapproved. Lords, thereafter, no periodical review has been done, perhaps because this court had put a, my lord, seal by accepting, my lord, some of the recommendations, by rejecting some of the recommendation. So, my lord's commission did not, my lords, go in for reconsideration or review of, my lord's, service conditions after, my lord, 2002. And this is, my lord's, para 11 of, my lord's, All India Judges, my lord, that judgment. Para 11, my lords, there is a direction that there has to be periodical review of service conditions by the commission. Then, my lords, I'll read, my lord's, suggestions. The way forward, proposed reforms. The above backdrop, lords, I have considered everything earlier, and with a view to addressing the long-standing imbalance between promotee and direct district judges, the following reforms are proposed for consideration of this honorable court. 1. Introduction of weightage system for promotee district judges while fixing their seniority vis-a-vis direct recruits. My lord, the commission, Justice Shetty commission, had devoted about 11 pages, my lord, so as to introduce, my lord's, weightage system. Before recommendations were made, my lord, discussion, my lords, goes on for 11 pages, and then there are recommendations. And those recommendations are ultimately brushed aside. Just in one line, there are 30 of All India Judges case. I'll read, my lords, that, and that is not approved only because they said the judgment of Supreme Court in, my lord, Sabharwal will take care of everything. And the judgment of, my lord, Sabharwal, that was designed or that was intended to give effect to, my lord's, reservation policy. That was not, my lord, to get over, my lord, this seniority or promotions. And, my lords, this honorable court has, my lords, expressed doubt as to whether, my lords, this roster system, my lords, introduced in Sabharwal can be applied in, my lords, in case of seniority, and that is in Ajit Singh 2, 1999. So, my lords, the time has come to reconsider, my lord, the earlier directions. My lords, I'll read only, my lord, 3 paragraphs. Of course, this has been read by my 1990. I'll read, my lords, Sabharwal's judgment. It's, my lords, 1995 too. I'll first, my lords, read para 30.
Mr. Dwivedi has already read those paragraphs.
Yes, my lords.
So you can just address your
My
submission.
lords, few more things, my lords, I will point out, my lords. Provisions, my lord, they are also, my lords, at page 23 and 24. 5 weightage system would be.
Yes,
The
you have said that it is also applicable to IS, IPS.
Yes. My lords, those rules were considered by the commission. And my lord, there are judgments of this court where, my lords, this weightage system had, my lords, not only applied, but that had worked well, very successfully. And therefore, my lords, commission had recommended to apply. My lords, kindly turn to my lords, page 23. 142, my lords. PDF 142. That's paragraph 10. While adopting the weightage system, certain practical concerns must be addressed to ensure that the mechanism achieves its intended purpose without giving rise to new anomalies of disputes. First, the Honorable Shetty Pay Commission had suggested granting 1 year of weightage for every 5 years of judicial service rendered before promotion, subject to a maximum of 3 years. However, in view of the significantly delayed promotions in most states and the steep disparity in the average age of entry, it would be appropriate to grant 1 year of weightage for every 3 years of service, subject to maximum ceiling of 5 years. This would more meaningfully recognize the long and valuable judicial experience of promotee officers while maintaining parity with direct recruits and bringing about harmony, justice, and complete fusion of district judges received from 2 different sources. Second, it's possible that a junior officer may receive accelerated promotion through limited competitive examination, 25% quota, strictly on the basis of merit. Such officers should not be unfairly placed below their seniors in the final seniority list solely because they have fewer years of prior service. The object of the weightage system is to restore fairness, not to penalize merit or efficiency. Third situation may arise where a comparatively junior officer receives promotion earlier than a senior due merit, and performance as the criterion for regular promotion is merit cum seniority and not seniority cum merit. In such a case, the senior officer, though promoted later, should not automatically be placed above the junior in seniority merely because he has rendered a greater number of years in the lower cadre. To address these complexities and maintain uniformity across states, it would be desirable either to, 1, incorporate specific safeguards in service rules, clarifying how much contingencies would be addressed. B, as a similar and more uniform measure, grant a fixed 5 years weightage to all promotee district judges, irrespective of their total years of prior service or the mode of their promotion. Whereas when discretion was given by your lordships in my lords all India judges, third, that High Court shall, my lords, make the rules. My lords, while making the rules, my lords, certain instructions, certain principles which are, my lords, there in the, my lords, lords, in Sabarbal's case, they have not been, my lords, followed by many high courts. As a result, my lord, the rules framed, they are not only different from each other, but my lord, there is no consistency, and they are operating to disadvantage of, my lords, several promotee district judges. That is a problem.
Yes, Mr. Pradhan.
For the direct district judges from Maharashtra, it might have a slightly different viewpoint.
Wait, please, my lords. My lords, I appear for the All India Judges Association in the matter, and my submissions are I have 4 submissions. First and foremost, my lords, I'm requesting that my lords may review the judgment and to an extent that provide weightage to these to the promotee officers on the basis of length of service, accepting the recommendation that of Shetty Commission. And my reasons are twofold. First, post, my lords, the requirement of the practice, the age disparity would increase further. Secondly, when the Shetty Commission made that recommendation, it was to overcome the age disparity. However, the 2002 judgment fell into an error when it says that roster would remedy that problem. Now, roster would really not do that. Lastly, my lords, pursuant to Rajneesh's order, this one, of course, the weightage is not alien to service jurisprudence. It is there with the IS also. And secondly, post Rajneesh, my lords, this really is justified because on the basis of length of service, such a weightage would be reasonable. So it would be in line with my lord's earlier order, which of course that benefit was not there in 2002, but that is now here today. So therefore I'm requesting my lords to review that to this extent. One. Second, my lords, the roster system has failed. It has failed for three reasons. One, my lords, it does not remedy the age gap. Secondly, because of the roster system, what happens is that the direct recruits get clubbed at the top. So they may at the entry level, it may so appear that there is a division, that there is 50% promote officers, 25% direct recruit, and 25% accelerated promote officers. But in the end, when they come at the higher bracket, it gets clubbed together as direct recruits are the one who remain standing because they have an age benefit. Now, my lords, my request is that this roster system may kindly be done away with, because it presumes that all three different modes of appointment can happen simultaneously. Now, they are all elaborate processes, whether it is for the 25% accelerated promotion or direct recruit, or the promotion by regular promotion by way of 50%. Now, it may be difficult for a high court to do all these things simultaneously. But in the end, so what happens is the promoting officer is available. He's working. In some places like UP, there is a rule which says that you can make him, you can appoint him against a vacancy by way of a short gap. But that appointment will not be carried towards his length of service, which means that he's virtually discharging his function as an additional district judge. He is doing all the judicial duties of an additional district judge, but for the purposes of his seniority, he's a phantom. He doesn't exist because his seniority will only be counted once he is appointed. His appointment is made under Rule 22(1). Now, when that 22(1) will happen? When the roster would be applied. So he is there, he is working, but he is waiting for all the administrative things to function while he is working, but he is phantom for that particular period. So, my lords, for any reason, it could be because there is an administrative exigency. It could be because there has been an incorrect determination of vacancy and High Court is continuing that exercise. It could be for number of reasons. But if we wait, if the officer has to wait for his turn to put in the roster when all three modes of appointments can happen simultaneously, it leads to a delay. So that's one reason, my lords. Secondly, my lords, post Rajneesh judgment, where my lords have said that a judicial experience is more than that of experience as an advocate, then in a roster system where a person who has already worked as a judge in the judicial services is put below a person who makes an entry at a direct level, that would be contrary to this, because if seniority has to be looked at, he has, as a judge, he definitely has more experience. The direct recruits, on the other hand, have an advantage of age. The accelerated officers have an advantage of age plus also experience, whereas these promoting officers have an advantage of experience. Now, all these three sources can be merged together and equalized if, instead of applying a roster, one, weightage is given to them, and two, if their seniority is reckoned for the promoting officers from the date of availability of the vacancy for them and their suitability.
Availability of vacancies, then it goes back to the roster system.
No, my lords, it would not. Because if we look at the earlier principle, for example, in BL Goel or OP Garg, which had been followed, and that has been noted down in the first National Judicial Shetty Commission report also. What they say is that so far as the direct recruits are concerned, they cannot claim seniority from any date anterior to their appointment. But in case of a promoting officer, he is there, he is in the service, this vacancy is also there, he is also found suitable, so which means his promotability is not in question, the availability of vacancy is not in question, then why should his seniority be delayed for no fault of his own? Therefore, there are line of judgments, my lord, and for example, OP Garg is actually quoted in Shetty Commission, where they've said that so far as the promoting officers are concerned, the criteria has to be promotability and whether there is a vacancy available for you or not. So if these two things are available, then simply because there have been an administrative delay for any XYZ reason, the seniority of that officer must not get suffered. So because today, my lords, a number of these promoting officers are losing on the seniority, it's because the promotions are not being made. And this problem is more in states which have a larger number of officers. So because the more the officers, the more difficult it would be for the High Court to realign and compute the vacancies. Lastly, my lords, how they make an entry into the system. So if the promotion from the civil judge cadre to the ADJ cadre is smooth, there is the problem today, my lords, is this, that in 2002, when my lord said that now there will be 3 modes of recruitment, one by promotion, one by way of accelerated promotion, and one by way of direct recruitment. Even for the purposes, paragraph 29 of the 2002 uses the term merit cum seniority. Now, in Gujarat judgment by my lords have held that that is not a straitjacket formula. But there my lords have taken clue from the Malik Mazhar judgment. Now, Malik Mazhar very clearly says that even the 2002, so far as that 65% promotion quota is concerned, you are going to not deny a promotion to a civil judge until he is found unsuitable. So it's rather the other way around. If a person is unsuitable, then you don't promote him. But what happens in practice, my lords, is this, that the word used in most of the rules that are placed on record, and because Learned Amicus has actually created a table summary of the rules in the first page of the volume. I'm not going there. In all of them, they use the word merit cum seniority. And this is because the 2002 judgment says so. And the method of promotion under this 50% quota is not very clear. So for example, whether there would be a written suitability test or not, how do you actually conduct the suitability, assess the suitability of an officer? For example, if suppose an officer has an integrity issue, then he's unsuitable, he's found unsuitable by the High Court for promotion. Then with passage of time, let's say in the next recruitment year, he may not become suitable because the unsuitability is of a nature that can't be overcome. But let's say, suppose in a batch of 100 civil judges, they pick up that these 20 are most suitable and ought to be promoted. Then those 80 who are superseded, would those 80 be then considered again in the next round? If that is the case, then it means that in the additional district judge cadre, while a junior may become senior even under that 50% quota, so it's not happened in a sequence, in a smooth sequence. The promotion, the civil judge who was senior in the civil judge cadre, when that officer will go in the edges, under the 50% quota, may also lose his seniority and may become junior to somebody, to the promotion cadre. Now, the rules are absolutely silent there. 2002 judgment only says that you have to consider merit. If an officer is found suitable, then apply the principle of merit cum seniority, and all high courts have framed their rules in that fashion. But how that would actually be put into practice, the rules are silent there. Now, my lords, if I may just point out, in the R.D. Mehta's, Ravidhan Suklal Mehta's case, the decision of my lords in Malik Mazhar was quoted. And if I may just request my lords to have volume 5A, PDF 1060, 1060, and the printed page is 1056. I'm just quoting the relevant paragraph, my lords, paragraph 139. This is where Malik Mazhar is quoted. Printed is 1057.
Paragraph 139.
139, my lord. So 139 quotes Malik Mazhar, and it says what my lords had held in Malik Mazhar is this, that until and unless an officer is found unsuitable, please do not deny that officer a promotion. Now, looking at this, then my lords had actually looked at all the the rules in the other states also and said, what we hold is that one must have an objective assessment of suitability. But in practice, because the rules are silent, there are no guidelines from my lords there, it says the assessment becomes subjective. For example, I may be in several of the cases, like in Gujarat, it has happened that a bunch of officers who had been found suitable, they cleared the suitability test, but because they were lower down in the list, they were not promoted because there were limited vacancies. Now in the next recruitment year, the expectation would be naturally that, okay, I was found suitable, so my turn did not come last time, now my turn has come. Now I'm relatively senior, now with this vacancy, I'll be promoted. But this time, he is held unsuitable. As a matter of fact, some officers who were the top scorers have been found unsuitable this year. So now the question is, I was suitable then, but there was no vacancy. Now with time, now this time I'm not suitable. So the assessment of suitability is also subjective. Whereas my lords have directed the high courts to frame rules and have an objective assessment. So therefore, my lords, if the assessment, the suitability assessment is objective, if a method is ensured that the civil judges under the 50% quota are promoted until and unless they are not found unsuitable, and with passage of time, because they are not competing inter se, they are not making an accelerated jump like the 25% competitive exam. So there, this hard burning would be really mitigated to a large extent. Secondly, this will not really have an adverse effect on the direct recruits also, because direct recruits anyway have an advantage of the age. So they have actually hopped into the cadre. So even if the roster is not applied to them, they are accorded seniority from the date on which they are born in the cadre, that is the date of their substantive appointment. Even then, they will have the benefit of being young in age. The age would work to their advantage. The same advantage would work for the limited competitive departmental exam also, because they get into the cadre much earlier than their counterparts who were there in the civil judge cadre. So even if the roster is not applied and he's not put at serial number 5 there, even then he will have the advantage because he will still be the youngest in the cadre. He'll still be the youngest. So my lords, with this, of course, we are in alternative. The All India Judges is supporting the prayer of the learned amicus for the quota. That is what we are. But primarily, we are requesting.
You are on weightage.
Yes, primarily, my lords, one on weightage, and secondly, the roster has to go, and third, the suitability has to come with a object. My lords may kindly lay down guidelines so that the suitability test which is done for promotion from civil judge to the ADJ, that becomes objective, and that doesn't remain objective because
That we have already issued directions in the All India.
my lords, what is happening is that in practice there are still some gap. For example,
The judgment which I have delivered in
yes,
way,
yes,
Bhattagar,
yes.
so far as suitability test is concerned, we have issued certain directions in that judgment.
Yes, Manoj. So suitability test for
For promotion from the civil judge senior division to the district.
yes, so correct, Manoj, because earlier the 2002 judgment had used the word merit cum seniority. So your lordship took the view there can't be merit at two stages, merit for LDCE also and merit for the civil judge with senior division to the ADJ also. So therefore your lordship says suitability.
No, and we have issued certain directions as to what should be the suitability test.
Yes, my lords.
Because some high courts were not having the suitability test, they were doing it on the basis of ACR, that's it.
My lords, additionally, the only thing I'm requesting is in additional to those guidelines is this: suppose an officer is found suitable, he qualifies the suitability test in, let's say, the current recruitment year, but he is not promoted because he is lower down in the seniority list.
And there are no vacancies for.
Because
correct.
So does he has to give that suitability test again?
Why not? If he has spoiled his career in that 1 year, he can be stopped again.
My lord,
To be tested at the time when he is being promoted.
Considered.
my lord, so that's exactly what my point is. So if he has done something that
you can't say that once you have qualified, then you are qualified for all time. Whenever vacancy comes, you should be promoted.
I leave it.
Your work
yes,
that will also be considered.
Yes, I leave it there. I'm most grateful, my lords.
Thank you for your on both the sides in Odal Council. You have done voluminous work.
Grateful, my lord. I'm very grateful.
Yes, Mr. Dr. Vivek Shapan.
Yeah, Lordship, I will start my proposition. By the virtue of Article 233, Clause 1 and Article 235, the issue of promotions of the district judges is exclusively in the domain of the High Courts. So this Honorable Court should only decide the guiding basic principles for the promotion of the district judges, and the concerned High Court should be at the liberty in formulating detailed rules and regulations for the promotion of the district judges. Now, Lordship, here are mainly the two issues. First is framed by the Honorable Court, what should be the criteria for determining seniority in the cadre of the higher judicial services. And the second issue is in the prayer of the amicus that the promotee judges should get the extra advantage to you can say for the appointment of the post of the principal district judges. So, Lordship, I will starting my submission from the prayer of the amicus first, and after that the issue framed by the Honorable Court on the second one. I am supporting the prayer of the amicus that the promotee judges should get some extra advantage in the appointment for the post of principal district judges. But the way and the manner and to the extent how can it be done and to what extent it can be done, it is totally different in my submission. First, it is my duty to bring in the notice of the Honorable Court that what are the concerned laws and the constitutional provisions relating to reach at that issue or the solution of that particular problem to get the, you can say the, for the post of principal district judges, the opportunity to the promotee judges. In Roshan Lal Tandon versus Union of India in 1967, which is against all of us, we know.
Against all of us?
No, no, no. In you can say of our side, Lord say. And my proposition that the second issue the proposition that the for the post of principal district judges, the promotee judges should be considered in the extra advantage must be given to the higher strength of bench. Why? Lordship, let me complete it. I am speaking on this end and I know this. Because in state of Punjab versus Davinder Singh, in morning the amicus is saying that is superseding the Roshan Lal Tandon versus Union of India. It is not. Because I also argued in that.
You are arguing in every constitutional bench.
No, Lord, in that particular bench. So that's why I am.
You have surpassed Mr. Tushar Mehta also in arguing in constitutional benches.
No, Lordship, it is just I am saying 2 or 3 points which are favorable to us.
Shankar Narayanan. Yes.
Lordship.
Today he is not here.
I am grateful, Lordship.
He was here.
Yes, sir.
In the first half.
Yeah, Lordship. In the state of Punjab versus Davinder Singh, we are discussing the subquota and quota. And that was only given by the state only after the empirical data. And that was for the creamy layer purpose in the SC/ST category.
So
and
one line, why don't you tell us how do you
yeah. So,
prepared?
Lordship, I am coming on
your position and tell us.
I am, Lordship, coming on that point.
So there are only 2 minutes.
Yeah. Lordship,
Within 5 minutes, I will go.
No, 2 minutes. We were granted 10 minutes as per your chart.
Lordship, I asked for the 30 minutes, but the time is reduced.
7 minutes are over, yes.
For that,
Okay,
you
Lordship.
complain to the, I guess, of the nodal council, yes.
Lordship, so please. So this provision that the how much quota should be given to the promoting judges must be considered by the bench of the higher strength, because the state of Punjab
You should have been on this side.
versus Davinder Singh.
Should have been on this side.
No. Lordship, they are different things. They are saying that the promoting judges should not get any extra benefit, but I am saying they should get, but
also refer to 7 judges. Yes.
yeah, that is the difference in both. And Lordship, also one more thing. If we compile the total LCDE and total promoting judges in the one cadre, and the direct recruits in the second cadre, and 1:3, the 25% from the promoting judges, whether it is from the time scale or the selection grade or from the LCD, and the 75% from the direct recruits. That is my proposition.
Yes, thank you.
Grateful to
Just to, sorry, my lord, apropos the question of my lord, the Chief Justice.
Yes.
My lord, on the suitability test, my lord, the Chief Justice's question, that is, my lord, decided as issue 6 in that 20.
In that matter. So that's
And
what
it's on page 891, volume.
and we have also laid down certain.
Absolutely.
We have also referred to their Gujarat judgment.
Page 891 of volume 5.
Laid down certain guidelines as to what should form the suitability.
What should form the suitability? Absolutely.
Tomorrow.
Lordship,
Yes,
in
yes,
that,
thank you, Mr. Mr.
merit cum seniority must be considered in that.
Yes. Tomorrow we'll be sitting in the first half. I have some difficulty in the second half. So we'll give some more time on the.
If required.
If there are so many on the other side. Yes.
Still, they all collapse. Different. So they'll all be saying the same thing.
Mr. Rahul is also
Just
there.
because they are 9 councils doesn't mean that you will all repeat the same thing again and again.
You are from Punjab or Haryana, Mr. Rahul? Kerala?
Kerala has benefited
Yes,
a
it has been
lot of practice from Kerala. The other day in my court also he was appearing from Kerala.
So Mr. Basant will have some competitor. So if it goes on, we will continue on Tuesday.
Thank God he doesn't say north to south.